to order. 6 months ago, many of my constituents in Ohio opened their morning papers to read the shocking news that law enforcement had discovered a human trafficking ring operating in Maran, Ohio, a small town about 50 miles north of Columbus, Ohio. 6 defendants were charged with enslaving multiple victims, including more than 6 migrant children from Guatemala, on egg farms in Marion County, Ohio. The details of the crime laid out by U.S. Attorney Steve Dettelbach were chilling. Traffickers lured the child victims to the United States with the promise of schooling and a better life. The parents of some of the victims even signed over deeds to their properties back home as collateral for debt incurred to pay for the journey. But not long after their arrival, these children, some as young as 14 years old, were forced to work 12 hours a day, 6 to 7 days a week. The work was grueling, and the living conditions were squalid, with children packed into a dilapidated trailer. They said that some of the kids were living in mattresses underneath the trailer. To compel them to work, the traffickers withheld their paychecks and threatened their families. As the indictment lays out, the defendants, and I quote, used a combination of threats, humiliation, deprivation, financial coercion, and debt manipulation to create a climate of fear and helplessness. 5 of the 6 defendants have now pled guilty. It's intolerable that human trafficking, really modern-day slavery, could occur in our own backyard in the 21st century. But it does. What makes this Marion case even more alarming is that a U.S. government agency was actually responsible for delivering some of the victims into the hands of the abusers. In 2014, more than 6 of the children found on the Marion egg farms traveled without their parents across Central America to our southern border. When they arrived here, they were entrusted to the U.S. Department of Health and Human Services, like thousands of other unaccompanied children who have been detained at the border. Under federal law, it's then HHS's job to find and vet a relative or trusted family friend to care for the child until their immigration court date, or else house them in safe shelters. Instead, HHS delivered the Marion children into the hands of a human trafficking ring that forced them into these slave labor conditions we talked about. How could this have happened in America? Well, after the release of the indictment last summer, Senator McCaskill and I launched an investigation to find out. How did HHS hand over a group of children to human traffickers? Was it a tragic failure to follow agency procedures in each of these cases? Or was the problem that the agency's procedures don't work and need reform? These were very important questions, not only because of the Marion cases, but because of the number of additional children who are at risk. Over the past 2 years, HHS has placed about 90,000 migrant children, the vast majority from Central America, with adult sponsors in the United States. That surge of migrant children coming into the U.S. illegally is a topic of some debate. There's certainly evidence that this administration's executive actions on immigration encourage the surge. But whatever your views on immigration policy, everyone should be able to agree that the administration has a responsibility to ensure the safety of the migrant kids that have entered government custody until their immigration court date. Unaccompanied children are uniquely vulnerable to human trafficking because many are in debt to the smugglers who arrange for their passage. The risk is that the smugglers may then force them to work off that debt once they arrive. That's why federal law specifically provides that HHS protect these kids from traffickers and others who seek to victimize them. We investigated these protections as part of a thorough 6-month bipartisan inquiry. The subcommittee requested and reviewed thousands of pages of child placement case files, internal emails, and other documents from HHS. We interviewed several senior officials at HHS. We consulted with experts in child welfare and trafficking protections. That bipartisan staff report has been issued today, and it details the troubling findings from that inquiry. Our conclusion is that the Department of Health and Human Services process for placing unaccompanied children suffers from serious systemic failures. The horrible trafficking crime that occurred in Maran, Ohio could likely have been prevented if HHS had adopted common sense measures for screening sponsors and checking in on the well-being of at-risk children. Protections that are standard, by the way, standard in foster care systems run by all the states, including Ohio. And unfortunately, the systemic defects that contributed to the Maran case appear to have exposed unaccompanied minors to abuse in other cases reviewed by the subcommittee. First, the victims of the Maran traffickers were placed with alleged family friends or distant relatives, which are known as Category 3 sponsors. As it turned out, the sponsors weren't really family friends at all. Two of them were basically sponsors for hire, strangers hired by human smugglers just to get the child out of HHS custody and then immediately pass them on to traffickers. HHS did not know that, though, because it does not insist on any real verification of the supposed relationship between the sponsor and the child, apart from the say-so of a relative. One Maran case file actually contains no explanation at all of the child's relationship with the sponsor or his family. We learned that this kind of lax relationship verification is standard practice in Category 3 placements, a lost opportunity to protect these kids and others. Second, HHS missed obvious indications that the sponsors in the Maran cases were accumulating multiple unrelated children, a sign that should have triggered greater scrutiny for the risk of trafficking. A review of the Maran case files reveals an interconnected web of sponsors of multiple children sharing the same address. HHS failed to connect any of these dots. Third, remarkably, HHS didn't visit a single sponsor's home to interview the sponsors and assess the proposed living conditions before placing them. We have learned that home studies are universally conducted in foster care placements, a close analogy to this situation. But HHS has done them in only about 4% of these unaccompanied children placements over the past 3 years. Only about 4%. This policy, of course, places thousands of children at risk every day. Fourth, HHS's procedures for what to do after a child is placed with the sponsor also failed. Only one victim of the Maran human trafficking ring was the subject of any kind of post-release home visit to check on the child's well-being. But shockingly, the adult sponsor was allowed to block the child welfare worker on contract from HHS from visiting that child, even after the caseworker discovered the child was not living at the home on file with HHS. As a result, the government missed another opportunity to uncover the crime being perpetrated. Incredibly, this was not a mishap. It is official HHS policy. HHS allows sponsors to refuse post-relief services offered to a migrant child, even to bar contact between the child and an HHS ORR care provider attempting to provide those services. Basically, when a sponsor says no, the caseworker is instructed simply to write, case closed. Finally, and this is hard to believe, at the time of these cases, if a potential sponsor said on his application that he lived with 3 other adults and that if anything happened to him, a backup sponsor could care for the child, which is sometimes required, HHS policy was not to conduct background checks of any kind on any of the sponsor's roommates or the backup caregiver listed on the form. None. Backup checks were only run on the sponsor himself. And this is even more incredible to me. If that check turned up a criminal history, HHS policy was that no criminal conviction, no matter how serious, automatically disqualified a sponsor. On these points, however, I can report that in response to our 6-month investigation, just this week, HHS strengthened its criminal background check policy effective January 25th, as outlined in our report. This is progress. But I continue to be troubled by the fact that HHS told us that it is literally unable to figure out how many children it has placed with convicted felons, what crimes these individuals committed, or how that class of children are doing, how they're faring today. The bottom line is that this is unacceptable. HHS has placed children with non-relatives that have no verified relationship with the child, who receive no home visit or in-person interview, whose household members have unknown backgrounds or criminal records, and who can freely cut off social workers' access to the child. Worse, when senior HHS officials were alerted to trafficking risks due to the Maran cases, and other evidence of children working in debt labor, they failed to adequately strengthen their policies, despite the fact that the Senate Appropriations Committee tells us that HHS has more than $350 million in unspent funds for this very program over the past 2 years. That's for this program, $350 million in unspent funds. Perhaps the most troubling unanswered question is this: how many other cases are there like the Marion trafficking case? The answer is HHS doesn't know. The subcommittee has reviewed more than 30 cases involving serious indications of trafficking and abuse of unaccompanied children placed by HHS over the past 3 years. But human trafficking occurs on a black market, and other forms of abuse occur in the shadows. The department maintains no regular means of tracking even known cases of trafficking or abuse, and it does little to monitor the status or well-being of the tens of thousands of children it has placed. There are, in the words of one leading care provider, untold numbers of effectively lost migrant children living in the United States. What I can say with confidence is that HHS's policies expose unaccompanied minor to an unreasonable risk of trafficking, debt bondage, and other forms of abuse at the hands of their sponsors. That must change. Today, we'll seek answers from the administration and discuss a path forward toward what I know is our shared goal of strengthening the system to protect every child in America. Without objection, the Joint Staff Report and the appendix to the report will be made part of the record. With that, I'd like to turn to our ranking member, Senator McCaskill, for her opening statement, and I want to thank Senator McCaskill for being a good partner on this investigation, for working very hard on this issue, and for her passion for these kids. Senator McCaskill.
Thank you, Chairman Portman. I want to thank you for bringing the topic of this hearing and the subcommittee's investigation to our top priority at this moment. It's been a cooperative and bipartisan investigation, and I appreciate, as always, the opportunity to work with you to bring these issues to light. If the Ohio cases that Senator Portman just described represented the total number of unaccompanied children exploited by their sponsors, we would be justified in holding this hearing. As the subcommittee has discovered, however, the unaccompanied children who were trafficked in Marion are only a few of those who have fallen prey to trafficking or abuse by their sponsors. I find the situation in front of us today unacceptable, and I am disgusted and angry. HHS placed one 16-year-old with a sponsor who claimed to be her cousin. In fact, he was completely unrelated to her and had paid for her to come to the U.S. as a mail-order bride. The minor, who had endured a sexual assault in her home country, was forced to have sex with her sponsor. She appealed to a post-release services provider for help and was ultimately removed by Child Protective Services. In another case, a 17-year-old was released to an unrelated, quote, family friend who reported living with 3 additional unrelated adult men. HHS released this teen to the sponsor without conducting background checks on any of the unrelated adult men with whom he would be living, without conducting a home study of his sponsor's home, and without providing any post-release services. Last June, this minor contacted HHS to let the agency know that his sponsor was actually the son of a labor recruiter who had approached the teen in Guatemala about an opportunity to work in the U.S. Upon being placed by HHS with a sponsor, the minor was forced to work 12 hours a day in conditions that made him sick, literally sick. The teen ultimately ended up living in a home belonging to his employer along with 14 other employees before running away. Similar examples fill the case files reviewed by the subcommittee, and keep in mind, we only reviewed a fraction of these files and found so many objectionable situations. We only looked at a fraction. Vulnerable and traumatized minors abused by their sponsors are forced to engage in backbreaking labor for little or no pay while being housed in unsanitary and dangerous conditions. This is not just a failure of our moral obligation to protect the most vulnerable. It is a failure of a legal obligation as well. Under the 1997 Flores Agreement, the Trafficking Victim Protection Reauthorization Act, and other statutes, HHS has responsibility for ensuring that unaccompanied minors are released to sponsors capable of providing for their physical and emotional well-being. At a minimum, HHS must make an independent finding that the child's sponsor, quote, has not engaged in any activity that would indicate a potential risk to the child, unquote. For many children, HHS failed to fulfill this fundamental responsibility. The subcommittee's investigation also revealed that HHS has failed to address systematic deficiencies in their placement processes, even after these deficiencies were highlighted by the Ohio case. In many cases reviewed by the subcommittee, HHS failed to ensure that the relationship between a child and proposed sponsor was even properly verified, failed to detect individuals who attempted to sponsor multiple children, failed to ensure sponsors had adequate income to support the child under their care, failed to conduct background checks on all the adults living in the sponsor's home, as Senator Portman mentioned, and failed to employ home studies and post-relief services to detect red flags for abuse and trafficking. In addition, the subcommittee found that HHS does not even maintain regularized, transparent guidelines governing the placement process and has not established specific policies and programs to protect unaccompanied minors from traffickers, despite a clear mandate from Congress in 2008 to do so. Further, HHS has failed to fulfill its obligation to clarify its role in the UAC placement process with respect to the other various federal agencies, and this is what really drives me crazy. HHS, to this day, is claiming once they put this child with a sponsor in Category 3, they have no more legal responsibility. Are you kidding me? And by the way, DHS kind of says the same thing. Well, that's HHS because they're children. Somebody is going to step up as a result of this hearing and take full and complete responsibility of these minor children that we have in our country. Nothing breaks my heart more than the notion that these parents and their children facing unspeakable problems in their home countries took a risk that every parent in this room can't even imagine taking. They said, yeah, take my child. I want this child out of this country because I love this child so much. And they believed America was someplace that they would be safe and maybe have a future. And we have two federal agencies that have abdicated their responsibility for the welfare of these children. Now, much of it was to try to get them out of detention. And by the way, everybody needs to understand there's categories. And if it's a relative or someone that's easily verified as a relative, that's Category 1 and 2. But keep in mind, if somebody can't prove Category 1 or 2, they put them all in Category 3 when you didn't have to prove anything. They reduced the time of home studies from 30 days to 10 days for one reason: get them out of detention, get them out of detention. Understand, these children, as we'll hear today in this hearing, are in caregiving facilities where they're visiting museums and they're playing soccer and they're getting 3 meals a day. What is wrong with keeping these children in detention longer in order to make sure that we are not placing with someone who's going to illegally use them as child labor or in sex trafficking? The priorities here are all out of whack. I'm not going to finish my formal prepared statement. I'll make it into the record because, frankly, I think it's important that all of us today quit thinking about what's on paper and think about these children and how hopelessly lost they are when someone shows up knowing that nothing's going to happen and says, yes, I'll sponsor that child. And then they stick them in a trailer and have them clean chicken coops 12 hours a day, 7 days a week for no money. We can do better in the United States of America. And I know there are not people at HHS or DHS that wanted this outcome. But because no one stepped up and took responsibility, that is the outcome we're dealing with. And we got to get it fixed, and we got to get it fixed now. Thank you, Mr. Chairman.
Thank you, Senator McCaskill. Thank you for your work and your staff's work on putting together a comprehensive report that I encourage everyone to read, and for your passion for this issue. We are now joined by the chair and ranking member of the full committee. I appreciate them being here. I'd like to offer them the opportunity to make some brief comments before we go to the witnesses. Chairman Johnson.
Thank you, Mr. Chairman. I want to commend you and the ranking member on instigating this investigation, this oversight. I share your outrage. This is shameful, what has happened. I think you all know I'm kind of big into facts and figures and root cause. And, Mr. Chairman, you asked how this happened. And again, your investigation shows the detail of what went wrong within the agencies. I guess I want to, in my opening comments here, kind of pull back and talk about the larger cause or causes of these tragedies, really. And I would first say that, the first proximate cause of this is how we've been handling the crisis of unaccompanied children. What's happened is we've become more, it's being swept under the rug. Remember when this was a big issue a couple of years ago? And by the way, we've got the chart up here. In 2014, where we hit over 50,000 unaccompanied children coming in from Central America. But what's happened in that intervening time period, and why it's not in the news so much anymore, is we've got more efficient at apprehending, processing, and dispersing. And unfortunately, we're processing and we're dispersing children into these horrific circumstances. So there's one proximate cause, our efficiency in sweeping this crisis under the rug, because we're also sweeping the crisis under the rug because we don't want to really recognize what I think is the root cause of this surge. Now, I realize there are legitimate differences of opinion in terms of what is the proximate cause of that surge, but just take a look at that graph. 2009, 3,300 unaccompanied children. 2010, 4,400. 2011, 3,900. And then in 2012, President Obama issued his executive memorandum, Deferred Action on Childhood Arrivals, which regardless of what the memorandum actually says, sent a very strong signal to children and families in Central America that if you get into America, you're going to be able to stay. And the reality is, again, regardless of what the memorandum says, if they get into America, they're able to stay. They're processed, they're dispersed into some of these horrific circumstances. I mean, take a look at the figures. The 28,000 that came in 2015, 3.6 have been returned. Of the 51,000 in 2014, 2.6 have been returned. So these children in these families, they use social media. They communicate with people back in Central America. The reality is they know if they get into America, they're able to stay. So again, I guess we kind of all breathed a sigh of relief in 2015 that there were only 28,000 unaccompanied children. A lot of families are coming in here as well. But again, 28,000 versus a few thousand in 2009, 10, 11. Now, let's put up the next chart, because this is what we got to be concerned about. Again, we're all good. The numbers actually came down in 2015. Look at where we are in just the first quarter of 2016. 2014, I mean, the massive surge, the crisis level, we had, again, total of 51,705 in that entire fiscal year, but in the first quarter, there were about 8,600. We're already up to 14,000 the first quarter 2016. Why isn't this big news? Again, it's because we've become more efficient at apprehending, processing, and dispersing, and we see the horrific results of that efficiency. So again, I just want to, we have to recognize what our policies are doing. We took a trip down to Central America, visited Guatemala and Honduras with Senator Heidkamp, Senator Carper, Senator Peters. In meeting with the president of Honduras, one of his requests of our delegation was, would you please look at your laws and end the ambiguity in your laws that actually incentivize our children, their future, from leaving their countries and coming to America. And again, the tragedy is they come into some of these circumstances because, let me repeat it one more time, we've become efficient at processing and dispersing and sweeping this under the rug. We have to end that sweeping under the rug process, recognize the reality, and change our laws. Thank you, Mr. Chairman.
Thank you, Chairman Johnson. Ranking Member Carper.
Thanks so much. My thanks to you and to Senator McCaskill for holding this hearing, to our witnesses for being here. There have been news accounts of late, certainly caught my eye and probably the eyes of some of you as well. The report was said that the number of folks who are here illegally has actually begun to drop, which almost seems counterintuitive when you think about it, because we're mindful of the flow of immigrants from Honduras, Guatemala, El Salvador. We're mindful of the President's proposal to bring in last year 2,000 Syrian refugees, this year 10,000 refugees, and yet that number of illegal immigrants in this country appears to be dropping. First, I didn't believe it, but now I'm convinced it's true. The question one might ask, well, why? Why is that happening? And as it turns out, if you add together the countries of Honduras, Guatemala, El Salvador, compare them to Mexico, my recollection is that the combination of those three countries that make up the Northern Triangle may add up to 25 million people. Let me see, Holly, do we have the number of, what's the population of Mexico? Do you know? Anybody know? I think it's under 200 million, but it's a lot of people. It's probably close to $200 million. So roughly 8 times more people live in Mexico than in these three countries combined. And there are more people going back into Mexico than there are Mexicans now coming into the U.S. And that's why the net flow is actually dropping, and the number of citizens here is actually dropping. 2 weeks ago today, I was in Guatemala, and with Vice President, with Secretary Jay Johnson. We met with the presidents of those three countries to talk about their Alliance for Prosperity. It's their version of Plan Colombia, and which they have committed to implement, to focus on governance, fixing governing institutions, to focus on security, corruption, a lack of rule of law, impunity. And the last one is just to focus on economic development, how to create a more nurturing environment for job creation, job preservation, which depends a lot on, frankly, winning the war against corruption and criminal behavior. That's their game plan. They developed that. And what we've done in a sort of a counter response is almost like Home Depot. You can do it, we can help. All right? They can do this stuff. It's laid out in their Alliance for Prosperity. And what we need to do is a number of things that are actually funded in the omnibus bill that we passed last night. We put last year about $750 million to support not to give money to these countries. The taxpayer dollars from these countries, and that $750 million ain't going to go to Honduras, Guatemala, and Salvador's governments. They will go to other entities. They will actually focus on corruption, rule of law, courts, prosecutors, prisons, and focus on economic development and so forth. I think it's a smart approach. So as we focus here on a terrible situation, which violates for me Golden Rule, which violates for me Matthew 25, the least of these. Obviously, we have to be concerned, care a hell of a lot about what's going on. It's shameful, but at the same time, we have to be able to walk and chew gum at the same time. And part of what needs to go on is we need to help these countries, in these three countries, which make up about 1/8 of the population of Mexico, get their act together and to turn themselves around as Colombia has. They can do it, and we can help. Thank you very much, Mr. Chairman. Thank you, Claire.
Thank you, Senator Carper. I'd now like to call our first panel. Mark Greenberg, who's here with us this morning, is the Acting Assistant Secretary for Administration for Children and Families, which is part of the Department of Health and Human Services. He was previously Deputy Assistant Secretary for Policy at the Administration for Children and Families. Before joining HHS, Mr. Greenberg was the Director of the Georgetown University Center on Poverty, Inequality, and Public Policy and was a Senior Fellow at the Center for American Progress. Bob Carey is also with us this morning, is the Director of the Office of Refugee Resettlement at the Department of Health and Human Services. He previously served as Vice President of Resettlement and Migration Policy at the International Rescue Committee. I appreciate both of you for being here this morning and look forward to your testimony. It's the custom of the subcommittee, as you know, to swear in all of our witnesses. So at this time, I'd ask you both to stand, please, and raise your right hands. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that the witness has answered in the affirmative. Gentlemen, all your written testimony will become part of the record in its entirety. We'd ask you to try to limit your oral testimony to 5 minutes. Mr. Greenberg, I'd like you to go first.
Chairman Portman, Ranking Member Ms. McCaskill, members of the subcommittee, thank you for inviting us to testify today. I'm Mark Greenberg. I'm the Acting Assistant Secretary at the Administration for Children and Families, and with me is Bob Carey, the Director of the Office of Refugee Resettlement. One of ORR's principal goals is to ensure that all unaccompanied children are released to sponsors who can care for their physical and mental well-being. The number of children that have been referred to ORR's care over the last number of years has grown significantly, and HHS has worked hard to adapt to this rapid increase in the size of the program, bringing on additional staff, expanding the network of providers, and adjusting a number of policies to respond to the unexpected fluctuations in migration, the needs of the children, and the challenges of managing a program that grew nearly tenfold over a 3-year period. I want to be clear that we view the Maran Ohio labor trafficking case as a deeply dismaying event. Child safety is a priority for us. We are committed to continuing to make revisions to strengthen our policies, to learn all that we can from this and our ongoing experiences in operating the program. As I explained in my written testimony, I can't discuss the specific details of the Children in Ohio case due to the ongoing criminal investigation, but will continue to assist the subcommittee in its work. In the next few minutes, I do want to talk briefly about ORR's process for placing unaccompanied children with suitable sponsors, and then describe a number of steps that ORR has taken over the last year to strengthen our policies relating to safety and well-being of children. Unaccompanied children are referred to ORR by other federal agencies, usually the Department of Homeland Security. They're generally cared for when they arrive in one of a network of ORR-funded shelters, while staff works to determine if they've got appropriate sponsors they can live with while awaiting immigration proceedings. Under the governing law, HHS releases children in our care to parents, guardians, relatives, or other qualified adults. Most children are placed with a parent. Most of those who aren't placed with a parent are placed with other relatives. We only turn to family friends if there is no suitable parent or relative. And in all cases, when we make placements, we seek to balance the importance of timely release with safeguards which are designed to maximize safety. ORR is continually working to strengthen its policies and procedures, and the last year took a number of steps to do so. Let me quickly highlight 5 changes that did occur. First, for a number of years, ORR has operated a helpline that had mainly been used by parents seeking to find out if a child was in ORR custody, or for sponsors that had questions with legal proceedings. Last May, ORR expanded that helpline so that it's available to children calling with safety-related concerns, as well as to sponsors calling with family problems or child behavior issues, or needing help connecting to community resources. Second, the Trafficking Victims Protection Reauthorization Act, TVPRA, requires a home study before a child is released in 4 situations. When a child has been a victim of a severe form of trafficking, special needs child with a disability, child who's been a victim of physical or sexual abuse, or a child whose proposed sponsor presents a risk of abuse, maltreatment, exploitation, or trafficking. In July, ORR broadened the circumstances where home studies would be used to include all children aged 12 and under being released to non-relatives or distantly related relatives. And later in July, ORR further expanded that requirement to apply in all cases where a non-relative has previously sponsored a child or proposes to sponsor more than one child to whom the sponsor isn't related. Third, under the TVPRA, ORR must offer follow-up services or post-release services in cases where there's been a home study, and the law says may offer such services for children with mental health or other needs that could benefit from ongoing assistance from a social welfare agency. In July, ORR began a pilot project to provide post-release services to all children released to a non-relative or a distant relative sponsor, as well as to children whose placement has been disrupted or is at risk of disruption and is within 180 days of release, and they've contacted the helpline. Fourth, in August last year, ORR started conducting check-in phone calls with sponsors and the unaccompanied child in their care 30 days after the child's release. The calls intended to identify any issues concerning child safety and provide sponsors with resource assistance. If the provider believes that the child is unsafe, the care provider needs to report this to local child protection agencies and/or local law enforcement. And fifth, ORR's longstanding policy had been to conduct background checks on other individuals living with a potential sponsor when a home study is conducted. And earlier this month, ORR enhanced its background check policy so that household members as well as backup care providers identified in a sponsor safety plan are subject to background checks in all cases. So in my oral comments, I've highlighted 5 areas where we've made significant changes. We discussed some additional ones in the written testimony. What I want to emphasize is that this is part of an ongoing process for us of continuing to review our policies to strengthen our safeguards as the program is expanded. We welcome the work that the subcommittee has done. We look forward to continuing to work with the subcommittee to strengthen the program, and we'll be happy to answer any questions. Thank you.
Thank you, Mr. Greenberg. Mr. Carey.
Mr. Chairman, I do not have written testimony, but I am happy to answer any questions.
You don't wish to make a statement?
No, I do not have a prepared statement.
Okay. Let's start where we finished with our own opening statements, and we look forward to hearing from you, Mr. Carey, in response to our questions, at least. Senator McCaskill and I started this investigation because of these public reports that HHS had placed a number of these unaccompanied children into the hands of human traffickers, specifically this case in Maran, Ohio. When we learned the details of those cases, we were shocked by the fact that HHS had approved these placements. They'd done so without really verifying the sponsors were who they said they were, without noticing the applicants were trying to accumulate multiple children, without even questioning, for instance, whether one sponsor had adequate financial means, who reported on your form that this person was making $200 a week in income. Without ever laying eyes on any of the homes the children would live in. Here's one of those homes. This is the trailer you see behind Senator Langford in Maran, Ohio, who we talked about earlier. There were multiple children in that one trailer. Worse, when a child welfare worker discovered that one child didn't really live where he was supposed to live, the sponsor refused to allow any follow-up services, just said, no, you can't even check on this child. And HHS policy was to say, fine, you can block these child welfare workers who are on contract with HHS. Close the case, don't do anything. That was policy. I have to tell you that when I heard those details for the first time, I thought, it sounds like everything that could go wrong did go wrong. But Mr. Carey, your deputy director in charge of the unaccompanied children program told our lawyers that, one, she was unaware of any failure to follow HHS policy in the Marion cases, and two, that she was unaware of any alternative practices that would have led to a different outcome. So I guess what I want to ask you both this morning, and I want an answer yes or no, is whether you agree with those conclusions from your deputy. So first, do each of you believe that HHS policy was followed in the Marion cases? Yes or no, please. Do you agree that HHS policy was followed in the Marion cases?
I've been advised by staff that it was followed, the policy that was in effect at the time. I do want to emphasize, as you heard in my remarks and as per my testimony, that we've made a number of...
So your answer is
policies.
HHS policies were followed. Mr. Carey, what's your answer?
I was not at ORR at the time, but I was informed that policies that were in place at the time were followed for these cases.
So this was based on policy, these horrible situations we've talked about. It's HHS policy that if a child turns out not to live where the sponsor says they will, and a caregiver offering post-release services wants to contact the child and make sure he's okay, the sponsor can refuse those services and block access to a child. Does that offend you? It just doesn't seem like common sense.
So-
Maybe I would ask, does anybody in the room think that that's offensive? Raise your hand if you think that's wrong, that you can't even check on a child.
Senator Portman, I do want to be clear that we're following the law that Congress enacted. Under that law, our reading of the law is that we do not have the authority to make these visits mandatory.
Well, laws that Congress actually enacted a specific law to avoid these kind of cases. And in fact, you just talked about it, and you said that if a kid's at risk of trafficking, you have to provide these additional services, and you didn't do it. So that's just not accurate. Let me ask you the second question. Do each of you agree with your deputy that there aren't any alternative practices that would have led to a different outcome? Yes or no?
Senator Portman, I
Just yes.
can't speculate. I can't speculate
just yes
for
or
an
no.
individual case as to whether that would have been the circumstances.
No, but
And as
Mr.
indicated,
Greenberg, you're a guy who
the
has
individual cases.
concern for these kids. You have a history of working in this area. You don't think that there could have been a better outcome with alternative practices?
What I can emphasize is that we're continually looking to how to strengthen our practices. As I've described, we've taken a number of steps over this last year to do so. I can't, for any specific case, say if this practice had been in place, would it have made a difference? But we absolutely want to ensure that we have the needed policies and practices in place, and we welcome the committee's recommendations to us for additional ones that we should consider.
Mr. Carey, do you agree with your deputy that there aren't any alternative practices that would have led to a different outcome?
We are deeply concerned about the well-being of all of the children in the care of ORR and do the utmost in our power.
But let me ask you if you can answer the question, yes or no, please. You're under oath. We've asked you to come here to testify. You didn't do an opening statement. At least answer the question.
With regard to, are there the procedures in place at the time were followed. There have additional procedures that have been put in place since that time. I would be reluctant to speculate what an impact on an ongoing criminally.
Deputy says she's unaware of any alternative practices that would have led to a different outcome. Do you agree with that, yes or no?
I would be reluctant to speculate about what might happen in a case that's in part of an ongoing investigation.
Wow. Mr. Greenberg, I want to ask you about a particular policy you've heard a lot about, the department's policy about home studies. As I think one of the other witnesses here today will tell us, state foster care systems, which are a pretty close analogy to what you do, never put a child in a temporary home without laying eyes on the living environment. HHS performed home-in reviews in only about 4% of the cases over the last 3 years. That's the information you gave us, 4%. If you had turned to page 212 of the appendix of the staff report, you'll see an email exchange. This is the appendix to the report, page 212. Do you recognize this email exchange, page 212?
The report has not been shared with us, Senator.
We gave you copies of this email. Let's provide additional copies of the email. Clerk, could you please provide those?
Yeah, and I'm reviewing the email now, Senator.
Okay, you got the email. Okay, good. My question is, do you recognize this email chain? It's with you. Do you recognize it? Just yes or no?
Mm-hmm. Yeah, it certainly appears to be our email.
Okay. Let me put this in context. Last summer, ORR was considering expanding home studies. In other words, to actually go and look at these places like this trailer. and decided to require them when a child under age 13 is placed with a non-relative. When that proposal came to you as head of the Administration for Children and Families, you wrote an email to ORR leadership raising concerns about it. Here's what you wrote. Quote, I assume the reason for under 13 is that it's a smaller number for a pilot and that we'll have the greatest concern about young children less able to communicate about their need for help, right? This is probably less likely to pick up the debt labor group. That's what we're talking about here this morning, the debt labor group, these kids who are forced to work to pay off this debt. Do you think that it would just go too far to extend to all children going to non-relatives? Sensible question. So, Mr. Greenberg, I assume you meant here is that kids 13 and older are more likely to be expected to work and therefore more likely to be forced to work off debt to coyotes and to traffickers. Is that right?
Yes, it is, Senator.
And here you're saying that ORR's policy change is not likely to help kids most vulnerable to labor trafficking. Is that right?
It is on that specific policy.
Yeah, okay.
You know, I have noted a number of additional policies.
You're onto something. Common sense. So in light of the trafficking risks you identified, you sensibly asked ORR, shouldn't we be performing home studies on all non-relatives? This is on page 211 of the appendix. In response, ORR Deputy Director in charge of the Unaccompanied Minors Program wrote back to say this, quote, you are correct about why we chose the younger children and a risk associated with the older children not being included, end quote. In other words, she said, yep, you're right. We're leaving out those kids who are most vulnerable to this debt bondage. That's exactly what happened. HHS approved the policy change without expanding home study to kids older than 13, despite you all knowing what you were doing for these kids who are in the kind of situation we're talking about here today in Maran, Ohio. So my question to you is very simple. Do you think home studies might have prevented the tragedy in Maran? If you'd gone and seen multiple kids living in a trailer like this, do you think there would have been a different result?
So, Senator, as
Yes or no?
indicated, I simply can't speculate as to whether a particular policy would have resulted in a different result. What I can say, and what you can see in my email, is that we were exploring circumstances under which we could expand the use of home studies. I expressly raised to staff the question as to whether we should be doing home studies for all cases involving
And your staff
non-relatives.
apparently disregarded that, and they didn't follow that policy. And I guess, you know,
Senator,
if you can't say this would have prevented the tragedy of Marion, then I think that justifies common sense. I mean, remember, a bunch of these sponsors were sponsors for hire by traffickers. And a bunch of unscrupulous people were trying to accumulate multiple children. That was obvious from any review. You didn't even have to have a home visit to see that if you'd looked at the files. The same address appeared on multiple applications. One of the sponsors appeared on other sponsors' applications under an alias. I just can't believe you wouldn't think that home visits would have revealed what was going on. It just defies common sense. Yeah.
So, Senator,
I've gone over my time. I'm now going to ask my ranking member, Senator McCaskill, if she has questions for the panel.
Before I get into my questioning, I want to say that DACA was not ambiguous. It was not ambiguous. Children here 2007 or earlier. This hearing is not about DACA. This hearing is about those children who appeared at our border, who came into our country, and frankly, no matter how you feel about the border, no matter how unrealistic your ideas might be about Mexico building us a wall, no matter how you feel about immigration, the bottom line is when a child is admitted into our country, the United States of America should be an example to the world about how we care for those children. Maybe they end up not staying here forever. Maybe they end up being deported eventually for some reason or other. But while they're here, we have an obligation that is in the foundation of what our country is, to protect them. Now, in 2008, Congress directed several federal agencies, including HHS, and you're a Harvard-educated lawyer, Mr. Greenberg, so I know you've read this law. It says very clearly, quote, these federal agencies, Congress says this in the law, must establish policies and programs to ensure that unaccompanied alien children in the United States are being protected from traffickers. It's black letter law, Mr. Greenberg. My question for you, have you established that policy or program specifically in response to this mandate from Congress in 2008? Yes or no?
We've established a whole set of policies and practices which are responsive to that mandate from Congress and that are intended to address the protection and the safety of children.
Well, Mr. Greenberg, I mean, first of all, does Mr. Carey work for you? Mr. Carey, do you report to Mr. Greenberg?
Yes, I do.
You do. So he's under you in terms of the organizational chart?
That's correct.
I was under the impression he was under the other assistant secretary who has not been confirmed.
No, I report to Mr. Greenberg.
Okay. Well, that was not clear, by the way, and this is from staff that's been pouring through your records and your org charts. So now we know. Can you fire Mr. Carey? I'm not asking you if you're gonna. I'm asking if you can.
No, I frankly don't know. I would need to talk with colleagues of the department, and I certainly have no reason that I would wish to.
Well, I don't want to disagree with you, but I have to say on the record that you have not established a direct policy or program in relationship to that. You've had drafts for years. How many years have there been drafts going around? You all haven't been there that long, but you have to know, right? There's not been a draft, or there's not ever been a regulation posted for even comment on this subject. Has there, Mr. Greenberg?
Senator McCaskill, I'd hope that you would both recognize the number of changes and improvements we've made in the last year.
You made a great improvement 3 days ago. I'm not sure it would have happened if it wasn't for this hearing, but you did. So no question, in the last 6 months, you guys have gotten busy. My question is, what's been going on since 2008? And why would you sit here and say the law doesn't give you any ability to protect these children when we specifically in the law in 2008 mandated that you do so?
Senator McCaskill, I want to be clear that our efforts to improve safety and do more to address well-being for the children in the program began well before July. In fact, when I testified before this committee last July, I described a number of these efforts at that time. So it has been an ongoing process. It will continue to be. We look forward to reviewing the committee's report and the committee's recommendations for what else we can be doing to strengthen our efforts.
Well, let me ask you a hypothetical. And Mr. Carey, I would appreciate if you would weigh in on this hypothetical. A 15-year-old Guatemalan girl is released to, quote, a family friend as a sponsor under Category 3. She doesn't show up for her hearing. What happens? Mr. Carey?
I can't speak to the specifics of speculate to the specifics of a case with which I'm not familiar.
This is a hypothetical case, Mr. Carey. This isn't a real case. You can speak to the specifics of this. You're not going to be able to avoid every question here. Let's try again. A hypothetical. A 15-year-old Guatemalan girl is given to a Category 3 sponsor, quote-unquote family friend, doesn't show up for her hearing. What happens? What responsibility do you have?
ORR's responsibility does not extend to the legal services that are the legal representation or the legal presence at a hearing.
Would it make you think, since the Congress said in 2008 you guys are supposed to be having policies and programs to protect these kids, would common sense tell you that maybe if this child didn't show up for the hearing, their sponsor is maybe not being responsible?
Senator, our responsibilities with regard to anti-trafficking are put in force from the day a child arrives into our care. They are screened for trafficking. They are met with by clinicians in individual and group settings many times over the course of their stay. Additional information is sought from every source available.
So the answer is no. You have no responsibility. You do nothing if she doesn't show up for her hearing. That's what you're trying to say. All these things happen ahead of time. I'm asking you what happens when she doesn't show up for her hearing. Does anybody call the sponsor? Does anybody decide that's time for a home visit? Does that occur? Mr. Greenberg?
So in a hypothetical situation, if there are post-release services being provided, then there would be ongoing follow-up with the child.
I'm asking specifically if the fact we know that the majority of children who show up for their hearings are allowed to stay in this country. We know that a much higher percentage of children are not showing up for these hearings if they're in Category 3. We know that. You know that, right? Don't you guys know? If you don't know that, and I know that, we're really in trouble. You know that, right? Mr. Carey, you know that, right?
We have limited information on the number of.
No, you've got to be kidding me. You're telling me you don't know that? You have limited information. All you do is pick up the phone and ask somebody. That's what we did. Mr. Greenberg, are you aware that Category 3 don't show up for their hearings as often?
I have not seen information to that effect.
Okay.
I can.
Well, this is just, I could go on for way too long, and I don't mean to be so hard on the two of you. You have good hearts, I'm sure. But you've got to step back from this. You've got to step back from this and look. What is everybody's doing is doing this. Out the door, we're done. And and you know what the Department of Homeland Security says? They say, well, they're children, it's HHS. And you guys say, well, we put them with a sponsor. It's not us. So no one is using the failure to show at a hearing as a moment of realization that somebody is watching this child that's not being responsible for their welfare. And you know what happens when that child's finally picked up? They get deported no matter what. So of course they're not going to come up later, because chances are, if it's a bad guy sponsor, he's worried about a whole lot of other potential consequences in his life. So it's just when I read all of this information, I mean, I would expect you guys to read this stuff and have it all memorized before this hearing, what we have learned from you. And the fact that you're not aware that the chances of a Category 3 sponsor showing up is much diminished from other kinds of sponsors, and that should be a warning sign. And I want to know this, when in fact, and this is, I know neither one of you will answer this question, but I want it on the record. Here's the bottom line. She doesn't show up for a hearing. There haven't been a blanket of home visits. Or the sponsor says, you know, we don't want you anymore to look at us. We don't have to look at you anymore. And she ends up being trafficked on Backpage, another investigation we're doing for sex. Whose fault is that? Yeah. And if you guys think it's not your fault, if you think you bear no responsibility for that, I think you're wrong. I think you're flat wrong. And I would like to see a turn here at this hearing and all of a sudden say, you know, we should take responsibility. Because somebody is going to take responsibility. If you need black letter law, I guarantee you we can get it. But I think the black letter law is pretty clear. I didn't go to Harvard. I went to one of those public schools. I went to the University of Missouri. And I will tell you, when I read that law, I don't think I would have the nerve to say that Congress hasn't given us the authority to watch these kids. Thank you.
Okay. Senator McCaskill, may I respond, please?
You may.
Yeah. Senator, as I've emphasized throughout, our overall concern is absolutely with the safety and the well-being of the children. We're implementing a law that Congress has enacted. Under this law, it is a law that simply didn't envision that there were going to be home studies in every case, that didn't envision that there was going to be post-release services in every case. Congress can choose to change the law to make it be that way.
Wait a minute. Establish policies and programs to ensure that unaccompanied alien children in the United States are protected from traffickers. What in the law is keeping you from establishing right now and putting it up today? By the way, your program manual, we can't even see it, what you're supposed to do. It's not even available to the public. But why don't you put up on the website today that you're going to have home visits every case when someone doesn't show up for a hearing?
They don't have the money.
What keeps you from doing that as part of this policy and program? Why can't you go back today and do that?
Senator McCaskill, I will be happy to go back and talk with our lawyers as to whether they believe.
Well, I'd love to
we have
talk to
the
your
authority do
lawyers.
it.
You're a lawyer. You know better. You know you can do that under this law.
Well, I can tell you, Senator McCaskill, that I've had multiple conversations about trying to identify what our authority is and what else we can be doing. What we're talking about today is our understanding of our authority under the law. If the committee or other members of Congress want to work to change the law or to clarify our authority.
Well, I need your
we would
lawyers
welcome
to
that.
get me in writing, and I would like it within a week. What it is in the law that prevents you from doing a home visit when a Category 3 unaccompanied minor does not show up for their hearing? What keeps you from doing a home visit? I want to know in the law what keeps you from doing that.
We will follow up and ask that question to our lawyers.
Thanks, Senator McCaskill. Of course, it's much worse than that because you have kids who actually told HHS, that this sponsor was not a family friend. It was someone to get me out of HHS custody. We have that information now from you all. We even have a situation where somebody said, as soon as I got to the airport, HHS bought my plane ticket. The so-called sponsor took off and put me in the hands of other people. They've told you that. So the situation Senator McCaskill talks about, of course, but it's even plainer than that. And obviously you have a responsibility here. I mean, you're not going to be able to say that there's not adequate legal basis for you to keep these kids out of the hands of traffickers when it's so obvious, when there was no check done. So, you know, I must say I'm very discouraged what I'm hearing today because you continue to try to evade responsibility when it's so obvious. Senator Heitkamp.
I just sit here and I wonder how we can possibly be having this conversation. How can we possibly not take in all seriousness the tragic situation of these children who are fleeing conditions that are unimaginable to us, coming to this country, believing this country has the ability to somehow protect them. But yet we sit here, important as what we are, senators and people, high-ranking officials, saying we don't have the ability to protect kids. There's no law. Have you ever, Mr. Greenberg, when you looked at this gap in so-called authority, which I agree with Senator McCaskill doesn't exist, but when you believed it exists, did you say, my goodness, we don't have the ability to do background checks. We don't have the ability to do home visits on a sponsor. We need to go to Congress and get an emergency bill passed to protect children. Did anyone in the administration have that conversation?
Senator Heitkamp, what I can say is that we have had very active conversations.
Do you understand why we're angry? Because every time we ask you a question, you go, how am I going to answer that? Answer it by telling us what conversations you had. This was your obligation to protect these children. What conversations did you have, beyond what we see here in these emails that would suggest to us that you put the safety and well-being of these children in a bill that was passed to prevent trafficking? You put the safety and well-being of these children first. What conversation did you have when you saw this obstacle that you've been telling Senator McCaskill that it exists in the law to change the law so that you would actually have access? Because I can tell you, as a former state official, if the state ran a foster care program under 4E like this, without home visits, they wouldn't be getting 4E dollars very long. There's no state agency that runs a foster care program like this. And I think we can completely appreciate the extent to which DHS was overrun. But going back again to Senator McCaskill's point, this was 2008. This wasn't the big surge. This is a long-standing problem. So what conversations, or let's ask you this from your opinion. Did you ever once think, I need to get the law fixed because these children aren't getting protected? You have a strong background and a strong history in protecting children. Were you ever personally troubled by your inability to protect children?
Yes. And let me say more to answer that directly. There was some discussion before about this shouldn't just be a paper process. And for me, this has never been a paper process. I can tell you that I have visited down in the Rio Grande Valley 4 times over the last 2 years. And when I go, I talk with children, and I talk with providers, and I talk with their staff, and I talk with advocates, and I talk...
And we all do. We've all been at the border,
So-
and I've spent time.
So,
So
but-
tell me what you
So-
came back from that. Senator Carper does a
So-
great job. You know, we're,
Yeah.
we're here to learn. So when you came back listening to those children, what policy change recommendations did you make at DHS to prevent this from happening?
What I'd emphasize is that it's very clear the way the law currently works that we've got limited authority around home studies, limited authority around post-release services, and I have made that, Senator Heitkamp, if I can explain, I have conveyed that very directly to this committee in my prior testimony. When I do public talk about the program, I make very clear the limited role that HHS plays.
Yeah,
and-
you know, and I don't mean to belabor this, but, you know, when I was Attorney General, we have a boarding school, an Indian boarding school, that we were hearing rumors about behaviors, and no one wanted to take jurisdiction. No one, you know, everybody said, no, that's somebody else. And I just thought, somebody has got to take responsibility for this. And so we just stepped into the void. And so occasionally, don't you think it's smart, even when you see something involving the welfare of children, to step into the void, to challenge the legal ramifications and say, let's do the right thing and sort it out later. And the problem that we have here is that there are bad people in this country. There's bad people all over the world. And, you know, I would be remiss if I didn't ask the question for Senator Tester, who had to leave. So I just want to say, okay, now we've got this horrible situation, which has been revealed, that's the subject of this hearing. And it's Senator Tester and my understanding that the egg farm is still in business. Is that true? The egg farm is still operating?
I have no knowledge other than press accounts. So.
Okay. What do you think happens when this all gets swept under the rug, when we're trying to really get at the bad guys? Get at the people who do this, who think that they can continue, because these kids are invisible, continue to operate with impunity, to operate businesses that are nothing short of modern-day slavery, when we don't report it, when we don't have testimony from these kids, because the kids are in the wind, they're gone. So my point, I guess, is that not only did we put kids at risk, but getting to prosecutions for people who do very bad things become impossible when we don't have the children protected. And so I would just say that I hope that what good comes out of this hearing, which has been, I think, more contentious than any of us thought it would get, that you guys really take this back and say, what's the perfect system? Maybe we can't always have the perfect system, but at least the worst state foster care system. Can we do as good as the worst case foster care system in the federal government when we're protecting children? And I think that is, I look forward to your recommendations on what we can do, not only from a law change, but also from a resource management change. Thank you, Mr. Chairman.
Thank you, Senator Heitkamp. Senator Carper would like to make a brief comment about it earlier.
I just want to correct something for the record. Thanks so much, Mr. Chairman. I did an audible here when I spoke briefly earlier in the hearing, and trying to explain why the numbers of illegal folks in this country is going down. And one of the reasons was because there are more people going from the U.S. into Mexico than the other way around. I mentioned I thought that Mexico had somewhere between 150 and 200 million people. We've got 122 million people. If you add up the populations of Honduras, Guatemala, and Salvador, it adds up to about just under 30 million people. So I think about the difference in population is not 8 to 1, it is 4 to 1. But that helps to explain the changes in migration numbers. Thank you.
Thank you. Senator Johnson.
Thank you, Mr. Chairman. Mr. Greenberg, according to your bio here, you joined the Administration for Children and Families in 2009, is that correct?
Yes, it is, sir.
Now, so I want to kind of direct my question to you because it coincides neatly with my chart, where I date back to 2009, again, where, just to remind people, about 3,300 unaccompanied children came in. The next year, 4,400, then about 4,000, and then it started ramping up. I really want to just have you tell me what was happening within the agency during that time period. I mean, I want to understand the history of your manpower, how you grappled with this, kind of what started happening in 2012, 13, 14, when it really exploded.
Senator Johnson, though I joined ACF in 2009, I didn't begin to work closely with the program until I became acting assistant secretary, which was late in 2013. So I can certainly speak to what's happened since that time.
Okay, we'll do so. Again, I want to hear, to the extent this has just overwhelmed your management capacity.
As I noted in my opening comments, the challenge for us was that the program did grow by nearly 10 times over a 3-year period, from about 6,000 kids to nearly 60,000 kids. And there is no question that in the summer of 2014, which was when I first testified before this committee, we were facing a whole set of capacity issues about how to address the number of children that had arrived and to ensure that we were able to provide adequate shelter for them. It's also the case that after that situation got under control as the numbers of kids went down, we did look broadly to say, this is a program that's grown 10 times in 3 years. What are the things that we need to do to strengthen it? And part of that involved significantly expanding the staff for the Office of Refugee Resettlement.
So to what extent, give me some numbers on that in terms of staff increases.
And I'll ask Bob if he can say precisely, but approximately authorizing something in the range of about 70 additional staff.
From what level? What was the baseline level to what? It went from where to where?
And again, I don't have the precise numbers in front of me. It was roughly 50-something full-time staff, some contractors, but it was roughly 50-something and adding another 70. But I could ask Bob if he can respond.
That is accurate. Approximately 70 were added over the course of the surge.
So one thing that we did was greatly strengthen our staffing. A second thing.
So let me just go. So 2009, we basically had about 50 people in this capacity. I mean, roughly, because nothing really changed much. And that was to handle about 3,300 kids, 4,000, somewhere in that level. Then started ramping up to 10,000, to 21,000, to 51,000, and we took the offices from 50 people to 70 people.
No, we added 70 more.
That's what I'm saying. Yes. 50 to 120.
Yes, so that's right.
So another 70 people, manpower, to handle literally 50,000, 51,000 more.
Well, in addition, over that time, we were greatly expanding the number of grantees who were providing shelter for the children. So let me just to highlight the other things that happened. We increased staffing. When the prior director of ORR left, we made the determination to have both an ORR director and to create a deputy director for children's programs, and to create a chief of staff to strengthen the overall efforts. We created a policy division within ORR. Senator McCaskill mentioned before the issue of policy, and we were concerned in 2014 that our policy wasn't transparent and that it wasn't readily available, and so we created a policy division, and they've been working to post our policies on the website. There was also a reference to the need for rules, and we are actively working on a notice of proposed rulemaking that it is our full intent will be out this year. So all of those things happened. In addition to that, I do want to emphasize that the set of things that we put in place around strengthening attention to child safety were things that we started doing later in 2014 and early in 2015. In addition to the ones that I talked about in my testimony, we strengthened the conditions under which we would do child abuse and neglect checks. We have put in place clear policies for when criminal convictions will matter for purposes of disqualifying a sponsor.
I'm running out of time. Okay, good.
Okay.
As I said, again, just from the outside looking in, we've obviously gotten more efficient at handling the surge. I do want you to address what's currently happening now in this first quarter. I mean, the fact that we went from 2014 about 8,600 in the first quarter. Again, 2014, to remind everybody, that was the biggest year, close to 52,000 unaccompanied children. So that year started out about 8,600 kids. This year it's already up to 14,000. Not quite double. What is happening? What's been your reaction to that? I mean, again, we're not hearing the alarm bells sounding here. But I would think, based on this committee's report, their investigation, alarm bells should be sounding. So what's happening here? I mean, to describe the efficiency of how we're moving these kids and what is being obviously lost through the cracks in our efficiency.
So between 2014 and 2015, the number of children fell, and fell from about 58,000 to 34,000. And when I testified before the committee in July, I talked actually at that time about how the numbers had fallen. The numbers then began rising. And normally there is a spring-summer increase and then falling after that. The pattern that we saw this year didn't correspond to that. So the numbers did continue to rise through the fall and through December. Our January numbers are looking lower than the December numbers, but there's no question that these were higher. So we have actively kept appropriators aware of those circumstances.
Well, okay.
We've been looking for additional
So my time's done. I
facilities.
guess my final comment is the true solution here is let's reduce and stop the flow, and that we have to really take a look at the policies in our own immigration laws that incentivizes this behavior. And listen to the president of Honduras who said, please end the ambiguity in our laws that is creating that. So again, I'd like to take the pressure off, but in order to do that, we've got to really look to the real root cause of what's driving this and create these kind of tragedies. Thank you, Mr. Chairman.
Senator Langford.
Gentlemen, let me bring up a couple things with you. Trafficking Victims Protection Reauthorization Act 2008. Here's the statute. The care and custody of all unaccompanied alien children, including responsibility for their detention where appropriate, shall be the responsibility of the Secretary of Health and Human Services. The care and custody of all unaccompanied alien children is the responsibility of Health and Human Services, including their detention if needed. Of the 90,000 plus children that are out there that have been put into care since 2008, if I were to ask you, how many of those could you find right now that we know where they are? How many of those do you think you could find? Give me a percentage guess of the 90,000 plus that are out there. They were placed in a sponsor's home, either saying this is a parent or a relative or a non-relative sponsor up there. Of the 90,000 plus, how many of them do you think you would know where they are? If I asked you to give me a phone number or an address, you could tell me.
So, Senator, I couldn't guess on that. I can tell you that we have the information at the time of release. If the child is receiving post-release services, we'll have continued information after
But you have
that.
no idea how many of them you could still contact today.
We do not. And again, this is based upon our clear understanding of the law and what we're authorized to do under the law.
The care and custody of all unaccompanied alien children, including responsibility for their detention where appropriate, shall be the responsibility of the Health and Human Services. So I'm trying to figure out the ambiguity in that. Would seem to be not just when they cross the border in that detention moment, but it is the care and custody. It is the, once you've transitioned them to a sponsor, is it your assumption that's no longer the care and custody? Now the law says once you give it to a sponsor, it's the sponsor.
So that has been HHS's longstanding interpretation of the law. And what I want to make clear is that in the majority of cases, when children are released, they're released to their parents.
Okay, so let me ask you about that.
so-
How do you know it's their parents? What verification are you using that this is a parent, and how are you selecting where they go and when it's a non-relative, where they're placed, who that is, who chooses.
So under the law that governs us, our first preference has to be for their parents.
Correct. So how do you know it's the parent? That's what I'm asking.
There is a process for verifying the relationship between parent and child. It will involve the use of birth certificates, other forms of identification.
Okay, so let me back up, because I've done the same thing that you have. I've been down to the detention facilities, which, by the way, before I came here to Congress, I was the director of the largest youth camp in the country. We had 51,000 guests a summer. We're a very large operation. So when I went and visited a facility where there were 1,000 teenagers that were there, I'm very aware of what it takes to do all the work around that. As I went and visited and talked to the kids and talked to the staff and interacted with the contractors that were there, I had individuals ask me later, what did you think? I left and said, that facility is exactly how I would have run my camp if money was no object. Because there was a tremendous number of staff and of buffers and all kinds of things wrapped around those kids. And what's astounding to me is how it runs the first 30 days that they're in the United States versus every other day after that for these kids. And so many of them never show up at their notice to appear, and we have no idea where they are, how they're being cared for, what has happened, how they've integrated into society. And we're aware that when we're put into a home that is not a near relative often, they never show up for a notice to appear, and we're aware they just disappear. Now, the struggle that I have is, if you're aware a high percentage is going to disappear, or you're aware that we're putting people at risk at trafficking, why wouldn't we hold them at their initial facilities where they're being well taken care of until court proceedings, and we know they're not going to be at risk in other locations, and they can go through their court proceedings, and many of those are returned to their home country. They do not have a relative here, and so they're being returned to their home country, but instead they're being released into the United States to people we don't know who they are. We're not checking up on them. There's not been adequate fingerprints. There's not been home visits. There's no acknowledgement that we know where they are months later, but we're not detaining them as the law requires. We're releasing them knowing full well we'll probably never see them again, and they're illegally into our country. Help me understand that.
Senator, I'd first say that I agree that these services are very good in the shelters.
They are. It's very good.
And we're very proud of them, and we would encourage any members of the committee that haven't visited, we would encourage you to visit the shelters. We have a legal responsibility to release the children, both under the Flores consent decree that governs us and under the TVPRA, which says that children need to be in the least restrictive setting in the best interest of the child.
So take me a year back, go a year ago, last January. We have a child that didn't come with a letter and a phone number, which many of these children are coming across the border, with a picture of someone, with a letter, with a phone number, some sort of identification. And what you didn't say before is what I know to be true. You're selecting these sponsors because the child has a piece of paperwork in their hand saying, this is who I want to stay with when I get to the United States, correct? Most often the child is walking in and saying, this is the person I want to stay with.
That will often be the case.
Okay.
Not always,
So,
but often.
but even parent, non-parent, then you're trying to guess then, is this really the parent? And if it's a non-relative, you're still trying to guess, is this really a good non-relative? Was this given to them by the coyote, or was this given to them by some parent in the past? They arrived then, they're placed in that. A year ago, did that person that they were being placed with, was there a fingerprint done for that individual that they were being placed with? Go back a year ago. So the sponsor, non-relative, when they said, this is the phone number and the location I'm told to go to, was there a fingerprint done for that sponsor? Yes or no?
So, Senator, you asked about a particular case or about policy?
Just a yes or no. Did we do fingerprints on the sponsors on a Category 3 non-relative that this child walked in and had a phone number for, not knowing really all the history of all that phone number, where that came from, that address? Did we do a fingerprint on that person?
Mm-hmm. Yes, there should have been fingerprinting done.
Did we do a home visit for that person?
a year ago, we would have only done a home visit if it fell into one of the four
If there's special
categories
needs, we thought
under
they
the
were.
law or.
Correct. So then, let me ask a question. Did we verify that person was a legal citizen of the United States?
We would not do that.
Why?
Because under the law, under the Flores decree, we've got an order of release, first to parents, then to close relatives, then
Even if
other
it's not,
relatives, then to
because
family friends.
no foster care in the country is going to place a child in a home of someone that is illegally into the United States, that we've not done a full background visit, we've not done all the process, because there's this sense that if we're going to have long-term custody or care, if it's a parent, that's a different issue. We're talking about a non-parent in here, to be able to place someone in a non-parent's home that is not a legal citizen of the United States, or that there were people in the facility that were not legal.
So Senator, both you and other senators have made a number of references to foster care, and I want to emphasize the foster care system is different in a lot of ways.
No, I understand it is. I'm just looking for the question
If
here.
I could just say a word about that. I mean, the foster care system does involve licensed and training of foster care the parents and facilities. It involves paying foster care maintenance payments to them. It involves a structure of states having caseworkers who are doing monthly visits to the child.
We all get that. We all get that. That's not the question.
So what I do want to emphasize is that's a different structure than this one. If Congress wants this structure to look more like the foster care system, that's absolutely a choice that Congress can make.
No, I think it's the decision on placement. I think it's not about long-term care and training and all those things. I get that. It's the decision on placement to say a person's fingerprint, background check. We know this person doesn't have criminal records. We know that that person doesn't have a notice to appear that they've skipped. And then that's obviously going to increase the chances that a child is placed in that house that's also going to skip a notice to appear. Or the most basic thing that Senator McCaskill brought up over and over again is this issue of if a child skips a notice to appear, that's clearly negligence. They're not following the law. That's a clear issue that they were negligent in not delivering the child to that appropriate time. That should set off an alarm of this clear statute that says the custody and care of alien children falls on HHS. So I guess all we're trying to figure out is what are we missing at this point?
Sure. So on the specific question Senator McCaskill raised, we will follow up and we'll go back to the lawyers and talk about that one. What I do want to emphasize for sponsors themselves, and again, it's important to appreciate how different it is than foster care. I mean, we're not paying these people anything. Right. They're not receiving, they don't, the children are typically not qualifying for public benefits. This is who should the child live with while they're awaiting their immigration proceedings. In most cases, that's going to be the child's parent. If it can't be the parent, we look for a relative, and only if we can't find an appropriate parent or relative would we ever go to the family friend.
Right. Thank you.
Well, I want to thank you, Mr. Chairman, for holding this hearing on this very important issue, and especially the abuses that are inflicted on these young children once that they get here. According to this, we now have 2016, just in the first quarter, 14,206. Then if this keeps up, this would be a record-breaking year. Is that true? Yes.
If it does keep up, yes.
Okay. Now let's talk for a minute about how they get here. They get here in the hands, 99% of them, at the hands of coyotes, right?
I would say often. I can't say a specific
I'm
percentage.
asking you straightforward questions. You and I know that it is the majority of them are in the hands of coyotes, right?
No, I can't offer a specific percentage. I can say when I talk to kids, I hear a range of
It
stories
is
about
a
how they get
well-known
it.
fact,
There-
Mr.
it is
Greenberg,
often
that the
with
majority of children the coyotes are paid thousands of dollars and they are transported to our border.
Yes.
I mean, Mr. Greenberg, we're talking about facts that are well-known.
Yeah, and Senator McCain, I absolutely agree that that's a very common thing. I just couldn't say that it was 99%.
Excuse me. Okay, so they're in the hands of coyotes, right? The majority of them, right?
Often.
You know, Mr. Greenberg, you're a very interesting witness. You and I know that the overwhelming majority of them are paid, coyotes are paid to bring them to the United States. They ride on the top of trains, and they often fall off and are killed. More importantly than that, young women who are brought by coyotes are invariably sexually abused on the way. We know that, right?
We know that happens often, Senator. What I am saying to you
We
is
also
just
know that
when,
these same coyotes that are bringing the children are also bringing drugs, right? Same cartels. Do you know that? You don't know that?
often.
It's more than often, Mr. Greenberg. It is invariably the case, and if you don't know that, then you are not doing your job. It is well known that the majority of children who come here are brought by coyotes, and it is well known that the coyotes are part of the drug cartels. Are you denying that? Are you denying that, yes or no?
Senator, I'm saying that I don't know that.
You don't know that. You don't
In-
know that, Mr. Greenberg, with your experience in that. I mean, this is crazy. Everybody knows that. Talk to any Border Patrol agent. Come with me down to Nogales, and they'll tell you how they got there, and they'll tell you who brought them, and they'll tell you what happened to the children along the way. And for you to sit there feigning a lack of knowledge of the facts is really insulting.
So, Senator, I can tell you first that I have talked to Border Patrol agents and have done so regularly when I'm down there. What I am told, and I don't wish to speak for them, but what I am told is that often the coyotes are independent of the drug cartels. But I don't have personal knowledge on this.
Why don't you have first-hand knowledge? Every other law enforcement agent does. All the Border Patrol people do. Everybody knows what the facts are. Mr. Greenberg, this is a very frustrating. Okay, well, let me tell you what's going on, Mr. Greenberg. Let me tell you. These are coyotes. They're part of the drug cartels. The overwhelming majority of children, their parents have paid thousands of dollars to have them transported, and many of the young women are sexually abused on the way. Those are well-known facts, Mr. Greenberg, and I don't know where you've been living, but you ought to know that, because those are facts. So then the question is, if those are facts, and they are, then why don't we do more in the country of origin? Guatemala, El Salvador, Honduras, where we can have these young people come to our consulate or our embassies, and there apply for this asylum, so they're not subjected to this terrible experience of being transported by coyotes, and who are drug dealers as well, to our border. And yet, the information that I have is that the State Department received 4,000 applications for the program and conducted 90 interviews. What are you doing down there at these embassies and consulates when young people come to you for shelter from the abuses and threats to their lives that are posed by the chaos within their countries, which are, by the way, mainly bred by drug cartels?
Senator, the administration does believe that having in-country processing is an important thing to do. The specifics of it are under the responsibility of the State Department.
Despite the fact that of 4,000 applications, 90 interviews were held. They may believe that, but they're not doing it. Has there been any increase in consulate personnel or embassy personnel to handle these cases in these three countries?
I'm sorry, I can't speak to that, Senator. It's best directed to the State Department.
So you wouldn't have any idea, even though your responsibilities are on this issue. Mr. Chairman, I can't ask any more questions of this witness. This is a definition of non-cooperative.
Thank you, Senator McCain. We are now into our second round, and I'm going to start, and I guess I'm going to focus on the issue that I think Senator McCain has just touched on, and Senator Langford, which is HHS unbelievably taking this position that somehow you're not responsible for these kids once they leave the detention facilities. You release them to a sponsor basically you're saying we have no more responsibility. You've taken that position even though federal law, as was just quoted, says that responsibility for care and custody of all of these unaccompanied kids rests with HHS. And even though Congress has mandated that HHS actually provide post-release monitoring in some cases, specifically, and even though there's a judicial decree that governs this program, also known as the Flores Agreement. In response to Senator Langford's questions, Mr. Greenberg and Mr. Kerry, your response was, well, the Flores Agreement requires us to get these kids out the door. That's basically what your response was. Let me just make it absolutely clear. The Flores Agreement does not authorize you to cut corners, period. It clearly states that HHS should place children with a family member or a family friend who is, quote, capable and willing to care for the minor's well-being. That's in the Flores Agreement. That's a quote. It also says, of course, that under the Trafficking Victims Protection Act, that you're forbidden from releasing any unaccompanied alien child, quote, unless the Secretary of HHS makes a determination that the proposed custodian is capable of providing for the child's physical and mental well-being. So this notion that you're going to hide behind the Flores Agreement or federal law, to me, is you shirking your responsibilities. It's clear that HHS is not permitted to skip reasonable precautions that are necessary to make the determination that's provided for under law, specifically, and under the Flores Agreement. To me, I guess that's the biggest concern that I have after today's hearing, is that despite our work, the work of others, the AP investigation, the back and forth we've had with you for 6 months on this, that you continue to think that somehow your legal responsibilities don't continue after you place a child. Let me ask you this question. Has HHS ever terminated a sponsorship agreement for failure to properly care for a child and resume custody of that child? Have you ever terminated a sponsorship agreement?
Not that I am aware of.
Mr. Kerry?
Not that I'm aware of.
So out of tens of thousands of kids, you have never, including in this case in Maran, Ohio, when those kids were living in that trailer with a bunch of adults, debt labor, you have never terminated an agreement.
So, Senator Portman, if I can respond more fully, our view that we don't have continuing custody after we release the child is a long-standing HHS view. It was the view before I got there. I'm happy to take it back to the lawyers and ask them about it again. It's also, if this is an area where Congress wants the law to be different, Congress should change the law.
The law already says that, and the Flores Agreement already says that. Have you read the Inspector General's report on this? It dates back to 2008. 2008. Have you read that report?
I'd have to go back and check.
Well, the Inspector General of HHS recommended that if there was any doubt about this, that HHS and the Department of Homeland Security should enter into a memorandum of understanding to clarify, quote, which department is responsible for ensuring the safety of children once they are released to sponsors, and which department is responsible for ensuring sponsors' continued compliance with sponsors' agreements. Have you read that? Have you read that report?
I don't recall reading that, Senator.
I would encourage you to read it. HHS has had quite a long time to think about it. You're up this basic question. I talked about that in my opening statement, but this is certainly the biggest one. It's just not taking home visits. 4%. It's no wonder you have these kinds of problems. Senator McCaskill.
What's the most important thing you're going to do after this hearing?
After the hearing, I'm going to read the committee's report. I'm going to ensure that we share it with staff and all other interested parties in the department, and that we actively discuss the findings from the report and what the implications are for our existing policies and what we can do to strengthen our policies.
And would you put an asterisk on the to-do list to ask the lawyers to put in writing why they think that you all have no responsibility after you place these children in particularly Category 3 homes?
Yes, I have that on my list from our earlier exchange, and
Yeah.
we will absolutely follow up on that.
Because it seems to be the heart of the matter here. I mean, let me just give you this factual recitation. On July 1, 2015, a federal grand jury indicted 4 defendants in Marion. In October 2015, 3 months later, HHS officials met with the subcommittee staff of this committee. The staff of this committee met with HHS. At that meeting, 3 months after an indictment, the HHS officials knew little or nothing about the children involved in the case or with the details of the placements with their sponsors. I mean, this lack of urgency is cultural, Mr. Greenberg. I mean, if I were sitting in your job and I picked up the morning paper and said 4 people have been indicted for trafficking children that your agency had placed in their care, I mean, red lights would flash, sirens would go off. There would immediately be a team of people to look and see what children were placed there. Were there other children placed there? What were we told? Did we look at the documents? And none of that had occurred. It was like, well, yeah. So when were you first notified that unaccompanied children placed by HHS had been trafficked in the Marion case? When was your first notification?
To the best of my recollection, I became aware when the indictment came out and there was press at that time. I can tell you that at that time, I did talk with ORR about our existing policies and what else we needed to do to strengthen them. As you can see and as you saw in my testimony, we broadened the home study requirements to later that month, in the month of July, to extend to circumstances where a sponsor was trying to sponsor more than one child or had previously sponsored a child. We built in September a requirement for the shelters to look to see, has a sponsor been trying to sponsor more than one child, or are children going, multiple children going to the same address?
Had your documents not been subpoenaed by the federal authorities at that point? The information about the sponsors, was that not, had they not come to you in the investigation about what information you had about these sponsors?
I can't speak to the specifics.
Mr. Carey, did they come to ORR asking for documents during their investigation?
I was not at ORR at that time.
Would somebody find out the answer to that question?
We can find out.
Because I'm just thinking, as a law enforcement, if I'm the prosecutor that's presenting that case to the grand jury, I'm going to want all those documents in hand as I prepare that case. So I would be interested to know if, in fact, they had asked for the documents, because you all have documents that were signed and executed giving those children sponsors. And some of those sponsors ended up being felons. Now, my last question, because I'm out of time and I know we have to get to the second panel. You've been struggling with trying to come up with a written policy for this program since 2008. There have been drafts of operational manuals, there's been drafts of policies floating around for years under consideration. You had these indictments in the middle of last year. Up until 3 days ago, it was the policy of HHS that it was okay if other adults in the house had been convicted of sex crimes with children. Now, can you relate to why I have a lack of confidence in your ability to draw up policies and procedures? How did that get missed? How did not looking at criminal backgrounds, even of the sponsor who takes over if the original sponsor disappears? How is that something in all these drafts and policies that are floating and, and we've got emails, comments on them, this has been around for years. How is that missed that you're going to place a child in a household with convicted felons where children have been the victims?
I agree that's a change that needed to be made, and I'm glad we made it.
That doesn't give me a lot of confidence.
May I clarify? The policy as it existed did not provide an absolute bar based on a criminal history, but it does not mean that the criminal history was assessed, and if it was seen as a threat to the child, the reunification did not take place.
I understand that it was possible for them to turn them down if they did the check, but they weren't doing the checks on the other adults living in the household. And secondly, if it came back, it was up to that individual to decide whether or not that particular conviction for child abuse was okay or wasn't okay. Somebody said in the process of this investigation, well, sometimes people get accused of child abuse in a domestic situation like that was somehow, we're talking about felony convictions for child abuse. Hello? I understand that they could have disqualified him if they'd run the criminal background checks, but they weren't being run on many of the people that would have been in these children's lives, and even if they found the conviction, they were not required to bar that person. That's the point I'm trying to make, Mr. Carey, and I don't think that there's much excuse for that. Thank you, Mr. Chairman.
Thanks, Senator McCaskill. I would add, as you know, that there was no criminal conviction that was too serious.
Right.
Even if they did the background check and found out that someone was an habitual sex offender, there was HHS policy was there was no
Automatic bar.
Criminal background that was too serious. Look, I know we need to get on the next panel. We've got some witnesses we really want to hear from. I would just end with two thoughts. One, this notion that there's not enough resources. Just so you know, in 2014, Congress appropriated $912 million. At the end of 2014, this is the period of time we're talking about, $200 million were left unobligated, not spent, not committed. That's about 25% of the budget wasn't even spent. In 2015, Congress appropriated $948 million, an increase. How much was not spent? About $278 million. So this notion of inadequate resources, just so you know, is not an excuse. And then finally, just to say, we have laid out here today 5 or 6 specific issues that we'd like you to take back. And I appreciate the fact, Mr. Greenberg, that you said you will read the report and that you will work with us to make some of these changes. Some were made this week. For instance, this criminal conviction issue was made on the 25th of January. As I said earlier, that's progress. I'm glad we had this opportunity to have the back and forth over the last 6 months. There's more to do, including clarifying this policy. I encourage you to read the Inspector General's report from 8 years ago. These are, as Senator McCaskill has said, issues that have languished for too long without being addressed. And unfortunately, we see that during this first quarter we have another surge. And we want to be sure that those kids who were abused, who were in servitude in Maran, Ohio, that their case can be an example, not just to talk about at a hearing, but to ensure that other kids don't fall into that same trap. And that requires you to do a better job of deciding where these kids ought to go and monitoring their situation. And you have every authority to do that under current law. And we insist that you do it. So thank you for being here this morning, Mr. Carey, Mr. Greenberg. We appreciate your coming to testify. And we now call the next panel.
we can kind of get the regular forum group together, just kind of talk about next step forward. It'd be nice. When we're on the floor for a vote, we can kind of get people together.
Thank you all for being here. We are privileged to have some experts before us to talk about some of the issues that we have just talked to HHS about. Our first witness is Tiffany Nelms. Tiffany Nelms is the Associate Director of Children's Services at the U.S. Committee for Refugees and Immigrants, where she oversees the organization's National Home Study and Post-Release Service Program for Unaccompanied Children. She has a background in case management, has worked on behalf of immigrant children and families for 15 years, and she's a licensed social worker. Jennifer Justice, in the middle of the panel. We're pleased to have you. Jennifer Justice is the Deputy Director of the Office of Families and Children in the Ohio Department of Job and Family Services. Among other duties, her office oversees Ohio's child and adult protective services, foster care, adoption, and child abuse prevention programs. Thank you for being here. Finally, last but not least, we have Kimberly Haynes. Kimberly is the Director of Children's Services at the Lutheran Immigration and Refugee Services, one of the great resettlement groups, which serves unaccompanied children, among others. She has over 20 years of experience in child protection and social work, including a consultant supporting a variety of refugee assistance programs within the Office of Refugee Assistance. We just heard from them. She has a master's degree in social work and management administration and community organization with a specialty in children and youth. Thank you for being here. Again, it's a custom of this subcommittee to swear in our witnesses, so I'd ask you please to stand and raise your right hand. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Yeah. Thank you. Let the record reflect that the witnesses answered all in the affirmative, and your written testimony will be printed in the record in its entirety. We'd ask you, if you could, try to limit your oral testimony to 5 minutes, and we'll have a chance for a little give and take. We may have some votes that come up, and we want to be sure and have the opportunity to have some dialogue with you. Ms. Nelms, we'll hear from you first.
Great. Thank you so much. Good morning. Thank you to the chairman, to Chairman Portman, Ranking Member McCaskill, and members of the subcommittee for the opportunity to amplify the voices of the thousands of children seeking safety and protection in the United States and to share their stories. My name is Tiffany Nelms. I'm a social worker and the Associate Director of Unaccompanied Children's Services at the U.S. Committee for Refugees and Immigrants. And for nearly a decade, I've worked with these children, and their perseverance and many successes motivates me to continue this work, but our failures to protect and adequately support them keeps me up at night. For over 100 years, the U.S. Committee for Refugees and Immigrants has protected the rights and addressed the needs of persons in forced or voluntary migration worldwide and supported their transition to a dignified life. We help the uprooted by facilitating and providing direct professional services and promoting the full participation of migrants in community life. We understand the situation because we work with refugees and immigrants every day. Let me tell you about a girl who I will call Karen. Her family eked out a meager living by selling bottled water and candy to tourists in a popular beach town in Honduras. After completing only a few years of school, Karen was forced to work and help support her family. For many years, Karen's extended family was targeted by gangs because they refused to pay a tax or rent. This tactic is commonly used by gangs to extort money from regular people. In exchange, those who pay the tax can live in, work in, or transit a community the gang has claimed. When she was 10 years old, Karen's uncle was murdered by the gang, a punishment for his refusal to pay this tax. The murder served as a warning, and Karen's parents fled, hoping to fall off the gang's radar. Their house was subsequently burned to the ground. At 14, Karen's parents allowed her to marry a man in another town to protect and provide for her. Karen became pregnant, and after the child was born, the physical, emotional, and sexual abuse started. She did not seek help from the authorities because crimes against women and girls are rarely prosecuted in her country. Karen eventually left her husband, and she and her child sought safety with her parents, who were living with Karen's cousin. However, this cousin was kidnapped, tortured, and murdered by members of the local gang as punishment for resisting their sexual advances and attempts to recruit her. The gang left her body in pieces on her doorstep as another warning of what could happen to Karen and her family. The murders of Karen's uncle and cousin were never investigated. This deepened the family's trust of the local authorities, and fearing she might be next, Karen fled to the U.S. border, seeking protection, where she was detained and transferred to the care of the Office of Refugee Resettlement. In the past 2 years, we've seen rapid increases in the number of children, most of whom qualify for refugee status, who are fleeing, seeking basic protection from violence, abuse, and neglect in their communities. These children's needs are not being met in their countries of origin. Approximately 10% of Central American children who are extremely vulnerable qualify for post-release services after reunification with a sponsor. This means they receive 3 home visits in 6 months. Many of these especially vulnerable children end up on a wait list, and some must wait up to 6 months after release before a provider is available to serve them due to capacity restrictions. There is no other system that places children, some that have no prior relationship or recollection of their sponsor, and provides no follow-up or monitoring of the child's well-being after the placement. Children who speak some English and at least have access to informal helpers such as teachers, pediatricians, and police officers, connections within their communities who are trustworthy and will notice any irregularities or, at worst, abuse or neglect. These are connections that are not guaranteed for unaccompanied children with limited English proficiency, often with no connections to their communities beyond their sponsors. These children are especially vulnerable to being abused, neglected, exploited, or trafficked. Post-release services are critical. They connect unaccompanied children to medical and mental health care, ensure that children are enrolled in school in compliance with compulsory school attendance laws, and provide children with access to legal representation, something that is not guaranteed for unaccompanied children and which significantly increases their likelihood of attending their immigration hearings. In addition to ensuring access to resources, post-release service providers monitor the children's well-being and integration to their new homes and communities. These social workers detect situations in which children are abused, neglected, exploited, or trafficked. For example, our staff has identified victims of labor and sex trafficking among this vulnerable 10% of the children that qualify for post-release services. Presently, post-release services are stretched thin, and the quality of these services are in jeopardy as we're asked to do more with less, increased caseloads, and not enough time to meet the needs of the children in our care. Here are some recommendations about how to remedy this. We suggest that post-release services become available to every unaccompanied child. Post-release services work. The children served through USCRI's program have a 95% attendance rate at their immigration hearings and similar outcomes for school attendance. We recommend that ORR expands capacity within the National Post-Release Service Network so children are served in a more efficient and expeditious manner, reunited with family in a timely and safe way, and able to access the education and medical and mental health care that they deserve. And we recommend that they streamline reunification processes in consultation with national post-release service providers. You may be wondering what happened to Karen, the girl I described in the beginning. Delays and lack of adequate representation resulted in Karen being deported just after her 18th birthday. Despite our best efforts, we are currently unable to locate her in country to confirm her safety. We do not know her whereabouts. We recognize that these children have fled to the U.S. seeking protection, and we take seriously our role as guardians while their immigration claims are reviewed and evaluated. When a child receives due process resulting in a deportation order, he or she must return to his or her country of origin. However, while these children are in our care, we can do more to welcome and protect the most vulnerable among us. Thank you.
Ms. Justice.
Thank you, Chairman Portman, Ranking Member McCaskill, and members of the subcommittee. Thank you for the opportunity to provide testimony to explain the foster care licensing process in the state of Ohio. I oversee Ohio's child welfare system at the Ohio Department of Job and Family Services and have held the position since 2011. I have worked in the child protection system for over 19 years, and in my current position am in charge of supervising Ohio's child protection programs, including protective services, foster care, kinship, adoption, the interstate compact for the placement of children in independent living services. Today, I want to highlight some of the important licensing requirements for prospective foster applicants. Ohio's foster parent applicants must be at least 21 years of age and must have enough income to meet the basic needs of a household. They must be free of any physical, emotional, or mental condition that could endanger a child or impair their ability to care for a child. Everyone over the age of 18 living in the house must submit to state and federal criminal background checks, as well as an Ohio alleged perpetrator search through the statewide Automated Child Welfare Information System, or SACWIS. A SACWIS search is done to see if the applicant has a substantiated or indicated report of child abuse or neglect. A foster parent applicant must disclose if a person between the ages of 12 and 18 years of age residing in the household has been convicted of or pled guilty to certain criminal offenses or adjudicated delinquent. A fire inspection must be completed and training must be completed. The required background screens must be completed no less than every 4 years if foster parents are to continue to be licensed. Criminal background checks are required to be conducted by all Title IV-E agencies per the Code of Federal Regulations. If an applicant fails to provide the information necessary to complete a background check, the person will be denied certification as a foster caregiver. If an applicant has a felony conviction of spousal abuse, rape, homicide, or sexual assault, he or she would be prohibited from becoming a licensed foster parent. This also applies to all adult household members. Ohio has a comprehensive list of misdemeanors and felonies that prohibit applicants from becoming licensed under unless certain rehabilitation standards are evident. When we look at financial stability, we look to see that applicants have enough income to meet the basic needs of every child. A foster applicant must provide proof of income for the household for the most recent tax year period and proof of income for the most recent 2 months, as well as their utility bills. Along with these requirements, a foster care home study must be completed. This evaluation of the residence is completed by a licensed agency's assessor and takes place physically inside the residence with the foster parent applicant present. Not all foster applicants end up being licensed. Some voluntarily withdraw, and some are denied a license. Applicants may be disqualified for offenses in their background check, or their living conditions may be unsafe. Although foster placements are often necessary, Ohio works hard to identify relatives and non-relatives who are familiar to the family as placement options to reduce the trauma that comes with removing children from their parents. Relatives and non-relatives over 18 years of age living in the home must undergo all the same criminal background checks as foster parent applicants. Their homes are also evaluated, and an assessment is conducted of their ability to provide a safe placement. Once children are placed with licensed foster families or approved relatives and non-relatives, monthly home visits occur until the child is reunified or another permanent placement is found. Monthly home visits are conducted by a caseworker employed by the agency that holds custody of that child. State policy reinforces this federal requirement to provide for the well-being of all children that have open child welfare cases. Visitation data is required to be reported to the federal government, and all states are required to meet or exceed 95% of all required visits. The approval process for children who are placed across state lines is defined in the Interstate Compact for the Placement of Children. This is also called ICPC. This is a statutory law in all 50 states and is designed to protect children placed across state lines so that they will be placed in a safe, suitable environment. In accordance with Ohio laws and policies, all home study and criminal background check requirements that I described a minute ago apply to these placements as well. Ohio appreciates the ongoing technical assistance provided by the Administration of Children and Families Regional Office, and I appreciate this opportunity to provide testimony here today, and I'm happy to answer any questions the subcommittee may have.
Thank you, Ms. Justice. We'll now go to Ms. Haynes, and I will say before you start your testimony, Ms. Haynes, a vote has been called, in fact, 2 votes, and Senator McCaskill and I have decided to stay through your testimony. Then we're going to ask you if you would please be patient while we run over and vote at the end of the first one, beginning of the next one, and we'll adjourn the hearing during that period, then come back to reconvene. So with that, don't be offended if we run out after your testimony, literally run out. Ms. Haynes.
Chairman Portman, Ranking Member McCaskill, and members of the subcommittee, thank you for this opportunity to provide the testimonial about the efforts to protect children from trafficking. My name is Kimberly Haynes. I'm a social worker for the last 5 years. I've been the director of Children's Services at Lutheran Immigration Refugee Service, where I oversee our ORR programs for unaccompanied migrant children, which include federal foster care, safe release support sites, home studies, and post-release service case management services. I have worked with unaccompanied refugee and migrant children both here and in the United States and in international contexts for over a decade. LRS is a faith-based organization which has been serving refugees and migrants for over 75 years, unaccompanied children from all over the world for over 40 years. LRS believes all children have the right to protection and family unity. As the only service provider that serves unaccompanied children throughout all stages of care, LRS is uniquely situated to identify the gaps in protection, make recommendations to improve the system, and U.S. policies and practices, ensuring the safety and well-being of these children. While I submit a more detailed written testimonial, I wish to express that the U.S. has a strong domestic child welfare system, which contains many best practices that we can use to enhance and strengthen the current system used for unaccompanied children. I will focus my remarks in two areas. First, on protection gaps in the current system, and second, provide recommendations to improve the family reunification practices so that incidences of trafficking or harm may be more readily identified, prevented, and mitigated. It is LIRS's position that ORR is in the best position to provide the care and protection for unaccompanied migrant children. However, it is imperative that adequate protection practices are in place to ensure the child's safety and well-being during and after release from ORR custody to sufficiently support the child and family's ability to protect, care for, and integrate into communities. Over the years, ORR has continuously revised and expanded its depth of knowledge and practice in serving this unique population. As I detailed in my written testimony, one excellent practice is the provision of post-release services for certain vulnerable children. In recent years, however, with higher number of unaccompanied children arrivals, ORR has revised certain policies in order to expedite family reunification and limit the amount of time a child would remain in ORR custody. ORR's budgetary limitations meant that its capacity to provide its full range of services was limited, and children were spending weeks in overcrowded, unsafe Customs and Border Patrol cells before being transferred to ORR. This situation was detrimental to their health and well-being. LIRS does not wish to see this happen again. LIRS has been serving unaccompanied children and their families for over 3 decades. We believe that our country can do better than releasing children to unsafe conditions due to the lack of resources. We need to treat these children as children first and foremost and provide the protection we afford all children while safeguarding their rights to family unity. LRS makes the following recommendations. First, ORR should prioritize child protection and safety in reunification decisions over reunification timelines and fiscal concerns. We need to see these as children whom are needing our safety and our protection and deserving family unity. Second, ORR should ensure that all children have access to some post-release services, at least at minimum 1 home visit after family reunification. These services should be trauma-informed, individualized, community-based, and case management services. Congress should also appropriate the necessary funds so that ORR can provide these services. Third, ORR should revise the sponsor assessment tool and sponsor reunification packet to ensure gathering of relevant information. This should be an in-person risk assessment of the sponsor, a sponsor needs assessment, and a sponsor orientation that promotes child safety, stability, and well-being. Fourth, ORR should monitor the impact of changes of fingerprint background check requirements and revise policy accordingly. The safety of children and screening of sponsors, including parents, must be more consistent and appropriately balanced. Fifth, ORR should enhance their engagement with NGOs and stakeholders in order to help improve their policies. ORR partners, such as LIRS, will continue to work with ORR on improving policies that utilize best practices in child welfare services. However, if ORR is to fully implement these best practices, they need the resources to do so. 6, Congress and HHS should provide resources for a nationalized child abuse and neglect database system. For child abuse and neglect checks so long that wait lists for multiple checks mean that children are waiting for reunification an extended period of time in facilities. Finally, Congress should provide ORR with the contingency funds so that it in times of high arrivals, unaccompanied children, or refugees, ORR can adequately provide these services required. Thank you for the opportunity to share reunification recommendations and best interests for unaccompanied children.
Great. Thank you, Ms. Haynes, and we appreciate the three of you, if you can, showing the patience to stay around while we recess, subject to the call of the chair. Look forward to talking about those budgetary shortfalls, since they aren't spending 20 to 25% of the money they're being appropriated. I don't know what they're telling you as a service provider, but I don't think that can be the reason. But we'll talk more about that. Senator McCaskill and I will return, and we are now recessed, subject to the call of the chair. Thank you all for coming back. We'll now reconvene this hearing. Senator McCaskill is on her way, and I'm going to start asking a few questions, and then she will be here shortly. First of all, thank you for your testimony and your willingness to spend time and help us with our report, help us with some of the ways in which we can help address the problems that we've identified today. Each of you has a strong history in this area. You bring different perspectives a little bit. Ms. Justice, more from the Ohio perspective and foster care perspective. And Ms. Haynes, you had some very specific thoughts that you thought would be helpful. And Ms. Nelms, we appreciate your testimony as well, particularly on the issue of home studies. My first question is about what we call home studies. I think they're incredibly important because it's an opportunity to have a face-to-face meeting. And HHS, of course, doesn't perform many. For 90% of the cases, I think they have no idea if the sponsor is actually who he or she says he is. In other words, what they're alleging in their application may or may not be true. Over the past 3 years, HHS has performed home studies in about 4% of placements, based on the analysis of our staff. Can you tell us a little more, Ms. Nelms, about what you think about home studies? In other words, for those who aren't following this closely, it's an opportunity to go and actually see something like that trailer, to see where these addresses are, to talk to the people face to face. Could you give us a sense of whether you think that is something that, as a care provider, you would think is important? And if you did a home study, what would you be looking for?
Thank you for that question. The home study process has been changing over the years. When I started in this field 10 years ago, as a social worker, we had 90 days to conduct a thorough assessment, interview the child, interview the family and home country, interview the potential sponsor and any household members, and visit the home, and really do our homework. And this process has evolved over the last 10 years. And I think in response to the increase in the number of children, and also we all want children to be reunified as quickly as possible when it's a safe and appropriate placement, and reduce their length of stay in detention. However, it shouldn't be by compromising the safety of the child. And some of the changes that have happened, we saw home studies reduced from 90 to 60 to 30, and last month the home study time frame we've been given is 10 days to conduct a home study. And that's now part of a bigger assessment, so we're one piece. And the only thing at this point that's required is an interview with the child and the sponsor and a visit to the home. And as a social worker, to maintain the integrity of that home study process, you really need one person looking at all the facts, corroborating the stories, confirming that proof that there is a proof of relationship to avoid situations like what happened in Marion, where the person presents as a family friend. And a social worker would quickly identify that in conducting a family tree, for example, with the child and the potential sponsor and somebody in home country, that they really they aren't able to match those names on that family tree. That's a very easy way to prevent something like this from happening. And this, unfortunately, is not something that we're able to do at this point with the recent policy changes.
Yeah, that's very disturbing. And in our report, we talk some about this, as you know, the fact that, as you say, 10 years ago, there was a very different policy in place, and it's gotten more and more strict over time, to the point that you have very little time, and that there's only, again, 4% of the cases now, is there any home study at all. And you're right, I mean, some of the follow-up questions are pretty obvious. The family tree is one. Maybe it's like, well, if you were a friend with the family, where does the family live? What color is their house? Who's their neighbor? What's the mother's maiden name? Just anything. They aren't asking for any of that, as I understand it. And I would think, Ms. Justice, in your work, you ask those questions in a much deeper way, and you don't place any kid without going through an extremely lengthy process. But at least to know, Ms. Nelms, that this is the person who they say it is. One of the cases, as you know, was this young man who was given the plane ticket by HHS with the sponsor to go to a particular place where the sponsor was supposedly living, gets off the plane, and this unaccompanied minor or unaccompanied child has testified that the sponsor took off, and literally, you know, the traffickers were there waiting for the kid, and the sponsor had been sponsored by the traffickers. You know, it was one of these just obvious situations that it was just a little bit of testing. And then in terms of the home studies, you can find out information about potential abuse that Senator McCaskill and others talked about earlier with some pretty simple questions and with some experiences you all have to be able to know what you're looking for. Ms. Justice, could you tell us just briefly, when you're required to conduct a home study, I assume that happens when you're going to place a child with a foster parent or probably any non-relative. What does that entail?
Sure.
What do you do?
Yes, so our foster home study process in Ohio is very detailed and thorough. We study homes, whether it be with relatives, non-relatives, or a licensed foster caregiver. Certainly having a license as a foster caregiver is much more comprehensive in nature, and there's training required. But in all cases, we are going to visit the residents. We're going to walk through the home. We're going to ensure that there's proper ventilation, heat, cool, depending on, you know, where you live. We're going to look at where the child would sleep. We're going to look at is there proper food in the house. We're going to engage the family and ask them very specifically how they intend to care for the child. What are their discipline policies, things like that. We're going to talk to the child as well and ensure that they feel safe. There's a multitude of things. We're going to look to see if that family has weapons in the home. How are they properly stored to ensure the safety of the child? It's a very well thought out process. We use checklists to make sure we don't miss anything, because we want to ensure the safety of all children that are in our custody, that that can't stay home because they're unsafe there. And so when they're in our custody, we need to make sure that they're as safe as they can be.
This question, you're from Ohio, and you obviously picked up your paper 7 months ago, and you saw this incredible story that was happening in Marion, Ohio, just 50 miles from where you live, probably. Assume you live in Columbus.
Yes.
What did you think? I mean, did this seem just unbelievable to you, given your background, or did it seem like something that did you know the Office of Refugee Resettlement does not perform any of these sorts of checks?
Actually, I am unaware of ORR's policies and procedures. Certainly, as a child welfare professional for my entire career, anytime I see a child that has been abused or neglected, it saddens me. It's troublesome. It's the worst thing that a person in my position can hear about. We are always striving to make sure that that doesn't happen. But there are bad people in this world, and it does happen. But no, so yes, you know, certainly is very disheartening, and I hope those children are better off now than they were.
Yeah, we hope that other kids are too. One thing we found in our study is the investigation revealed that HHS doesn't know. I mean, we don't know how many kids are in situations like this. And Ms. Haynes, you talked a little about the national database and criminal checks. One question we've asked them at HHS, as you know, perhaps, is how many kids have gone to live with a convicted felon? And guess what their answer is? We have no idea. We don't keep track of that. So even if they're doing fingerprinting on some of these sponsors and asking about criminal records, which, as you know, until this week, you could be a child molester, a rapist, you could be a murderer, and there was no automatic ban to placing the child. But even when they did know what the record was, they don't keep any database of it, so there's no way to know. So tell us, I mean, I'm not sure if that's what you're getting at when you talk about a national database in your testimony, but what do you think ought to be done there in terms of at least understanding what the problem is?
As you mentioned, I think there's a couple of layers of protection that need to be put in place, and that's practical, balanced of can checks across the board, no matter who's sponsoring the child. I think the reality is also that checks are having to be done in multiple states. We know the population, we know that they are highly mobile, we know that people move, and having multiple states have to run this takes a lot of time. Therefore, that also keeps kids lingering in shelter situations rather than moving forward through the reunification. I agree with you that it sounds like that there needs to be stronger policies and practices in place that sort of outline what kinds of convictions or what kinds of outcomes the can checks have that would limit the reunification of children to potential sponsors. That is a concern, and again, without a home study or other post-release, that is one potential opportunity to identify potential concerns.
Thank you. And if you don't mind, if you could flesh out your national database idea very quickly, and then I'm going to turn to Senator McCaskill.
Currently, can checks are done by each state and individually by each state within that state. That doesn't circle or doesn't come and connect all 50 states into one massive database. So there is no way to run one name in a national database that would allow us to look at any state that they may have had a conviction of any kind.
Great. Thank you very much. Senator McCaskill.
And we didn't even get a chance this morning to get to all the problems we have with the portal at HHS as it relates to trying to determine somebody who's requested multiple sponsorships, someone who has using the same address for multiple cases in terms of getting sponsorships. Let me ask all three of you. First, do you think there should be a continued role of the federal government once these children have been placed? And if you believe they should have a continuing role, who do you believe in the federal government, from where you sit, is the best equipped to take the responsibility of trying to monitor these children's environment after they have left to reside with a sponsor or family member? We'll start with Tiffany and with Ms. Nelms, and then go to Ms. Justice, and then to Ms. Haynes.
Thank you, Senator McCaskill, for that question. I do believe that it would be helpful if ORR did extend their responsibility for the kids after reunification, and currently, as they mentioned, the post-release services are voluntary. We share the concerns regarding that arrangement, and there are many situations where by the time we receive a referral or there's capacity within the network to serve a particular child, they have disappeared and we're not able to locate them. And in some circumstances, we can make a report to Child Protective Services about that child or to law enforcement, but most of the time those reports won't be accepted because people are free to come and go, and there's really no one with the authority to try to figure out where that child is.
So a 15-year-old child disappears, not at where they're supposed to be. Are you saying that if the child is not where it's supposed to be, then law enforcement, or a 16-year-old child, law enforcement and Child Protective Services in some states will say, they can go where they want?
In many cases, that's the response we get, and USCRI serves children. Right now, I think we're serving children in 40-something states. So we have experience in many, many cities across the country, and that is the response that we get quite often, unless we have had situations where if there was a trafficking concern, that they did a little more research into that case. But as Ms. Haynes mentioned, this population is highly mobile, and they move, and they can be hard to locate, and that's concerning. With the restrictions we have right now with post-release services, we don't have enough funding to serve the children that could benefit from post-release services. So they end up on a wait list, and they could be released for 6 months or more.
This is a question I didn't ask the first panel, but are the sponsors required to notify anyone if they change address?
They technically are supposed to, but there's really
and
nothing
they notify
holding them
ORR?
for that. I would say in most cases.
Do they notify? Are they supposed to be notifying HHS?
They're supposed to notify the court and of any changes of placement.
The immigration court.
Immigration court, correct. But on our end, as post-release service workers, we do our best to locate children through a number of ways. We try to establish contact with family and home country to see where the child is. But if 4 or 5 months have passed since they've been released from ORR care, it's quite difficult.
And Ms. Justice, do you believe the federal government should continue to have a role after these children are placed?
Right. So as I stated earlier, I'm somewhat unfamiliar with ORR's current policies and procedures, but what my experience tells me is that when we in Ohio place children with relatives, non-relatives, or licensed foster parents, that we need to continue to see these children to ensure their safety and stability.
Right. And Ms. Haynes?
I do believe ORR is in the best position to provide the care and custody and ongoing supervision and support for these children after release to sponsors.
Okay. And by the way, is there anybody left in the room from HHS? No one? Not even somebody's assistant to the assistant to the assistant? No one here works for HHS? Well, that's really a telling. Okay. In your opinion, why have they changed the policy on home study to make it more and more circumspect in terms of how much time you have and how often they're done? What do you think is behind that, Ms. Nelms?
I think there's a number of factors. I mean, we saw the influx in 2014, and ORR, I think, is working very hard to expand their resources, and a lot of those resources have been directed to the residential facilities. And the expansion of these post-placement services, home study services, has not kept up with the growth in the population. And so I think there are ways the reunification process can be streamlined, and some children are going to good sponsors, and they don't need to remain in care for months on end. So there are situations where there are benefits to that. But I think that the largest part of this recent policy change is that there is a tremendous wait list right now for children waiting for home study post-release services, and the wait list fluctuates between 1,400 and 2,000 kids at any given time waiting for a service that one of our organizations provides, because capacity hasn't been expanded. And so I think in looking to address that, children are released more quickly if home studies take 10 days versus 30 days.
So resources aren't helping in that they're not able to utilize those resources quickly enough to deal with being overwhelmed by the great increase in numbers of children? Is that essentially what you're saying? Because, they got money. I mean, the chairman said they have money. We've looked, they have money. So is it, and I know they've hired contractors to help with some of this. Always there's a contractor. So I'm curious if, from your perspective, is it just they haven't got the infrastructure in place, and so they, for example, changing the home study from period of time from 30 days to 10 days? I mean, obviously that's really problematic. Is that just a matter of them not having the capacity to handle these kids?
USCRI serves 2,500 kids a year through our home study and post-release service program. We're one of 11 providers that works with these children, and in conversation with many of the other programs, we are ready and willing and able to add additional capacity to serve these children so they're not waiting months at a time for our social workers to get to them. So I'm not sure exactly where the disconnect.
Well, I would like to have staff follow up, if the chairman would agree, that to with the 11 different providers that you just referenced, and talk about the capacity you have and figure out where the disconnect is between the capacity that's out there and the fact that we are not, in fact, utilizing, that we're going to this third category of people that if you can't prove you're really related to the child, you get the child anyway. I'd like to kind of drill down. Do you feel like there has been enough conversation between these groups and ORR as to the problems that are clearly present in the system as it's now operating?
You're speaking to one of the recommendations that we made. I think we could do a better job at collaborating, and many of us have served these kids for many years, and we know the challenges and the situations that they find themselves in that are very troubling. And it would be good if we could increase that communication to talk through potential policy changes before they occur.
Right.
And have these negative effects on the
Yeah, you all should be heard from before they do. I mean, they've been working on policy and programs now for, it'll be close to a decade, and we still don't have anything. So it seems like it's not like they're rushing them to print. So it seems like to me there's time to talk to the people who are on the ground dealing with these children day to day. Let me close. I know I'm over time, and I appreciate the chairman's indulgence, but let me just close speaking to the three of you. I know that I'm sure all three of you are college educated, correct? And all three of you had choices about your careers, and all of you decided that you were going to go into a line of work that is full of heartbreak and sadness. And I just want to thank you.
Thank you.
Thank you, Senator McCaskill. Yeah, thank you for what you do every day for the kids who we both represent, but also thank you for being willing to help us to improve conditions for kids going forward. I mean, this is, I think, an extraordinary failure. We just talked a little about the importance of home studies and post-relief services. Again, look at this email that without this investigation we never would have known about. This is a email written by the gentleman who was here earlier, Mr. Greenberg. I assume the reason for under 13 is it's a smaller number for a pilot and will have the greatest concern about young children, less able to communicate about their need for health. Right? But this is probably less likely to pick up debt labor group, which is what this was. These were young kids. They were minors. Do you think it would go too far to extend to all children going to non-relatives? They didn't do it. I mean, after that question, what would the answer be? The answer is, of course. We would want to cover these kids who are more likely to be subject to the kind of trafficking that we see of kids having to work off the debt. Their paychecks were withheld. I mean, these kids were working 12 hours a day, 6-7 days a week, no pay, because their paychecks were taken to pay their debt. Finally, just to make this clear, on post-release services, which is what this is about in addition to home visits, the sponsor can just say no. Under current HHS policy, the sponsor can say to you, Ms. Haynes, as you go to knock on the door to say, just checking to see how this young man or young woman is doing, to see whether what's on this application is still valid, they can say, take a hike. And your job is then to report back to HHS, case closed. That's what they ask you to do. So, yes, there have been some progress made, as I said. We appreciate that, including this pilot program. But it's not a matter of resources. We've been able to go through the appropriations process and look, and it's not just recent. During the time period we're talking about, 2014, they didn't spend 25% of their budget. It's a matter of commitment, and it's a matter of organizing that department in a way to handle this big influx. I mean, it's not a mystery that this is going to continue to be an issue. So Senator McCaskill and I want your continued input because we want to be sure that one of two things happen. Either HHS makes further progress, gets its act together, follows, again, recommendations that Senator McCaskill said have been out there for almost a decade, puts together a plan, works with DHS and others to ensure we know who's responsible for these kids. This Flores agreement that they talked about as a way to get out from their responsibility, it does not limit their ability to take care of these kids. In fact, it insists that these kids are taken care of. It says, to a family member or a family friend who is capable and willing to care for the minor's well-being. That's in it. The legislation Senator McCaskill talked about earlier, it specifically says, capable of providing for the children's physical and mental well-being. So we think they have the authority to do it. But if they are not going to take care of these kids, protect them as the law provides, then we're going to look at additional legislation. that makes it absolutely clear, or other ways, perhaps through the appropriations process, to deal with this. So we want your continued input. We know this is a tough issue. We know this is not going to be easy to address. We know from the first quarter results this is an issue that is likely to increase pressure on ORR. But boy, we have revealed so many failures here, including lack of consequence. You talk about the fact that they're supposed to tell HHS if they change addresses. I would ask you, Ms. Haynes and Ms. Nelms, do you think there's any enforcement of that? Any consequences? Not based on our study. Zero. No accountability. So we have an opportunity here to make a difference in the lives of many of these children going forward, and we will look forward to working with you to do that. I want to thank Senator McCaskill for being a great partner on this. It's been heartbreaking, as she says. It's a tough issue, but it's also an interesting challenge for all of us to say, you know, regardless of how we feel about immigration policy, and there are big differences of opinion on that. I expressed earlier some of my concerns about that executive order, but when these kids are here, when they're in the custody of the United States government, they cannot end up in that trailer, working 12 hours a day as minors, 6-7 days a week with no pay. It can't happen, not in this country. So thank you, Senator McCaskill. Thank you, your staff. The staff has worked really hard on this, and I want to particularly single out Rachel Tucker of my staff for her remarkable work on this. And I want to thank you all for being here today to share your testimony and your commitment to continue to work with us on this issue. The hearing record will remain open for 15 days for any additional comments or questions by any of the subcommittee members. And with that, this hearing is adjourned.